How's it going?
Oh, it's going great. I can't complain. It's a beautiful day.
This morning it was kind of nasty out, but the sun came out.
Well, it was great for me because the reason why we have Docket in the afternoon is because they had career day
Okay.
at almost elementary school.
Okay, cool.
And they're so I don't know why I'm raising my voice like I'm shocked by it all. But young children are so intelligent. It is always nice to see things through their eyes. My brother calls it new eyes. They have new eyes, so that's good.
I remember when I first started practicing, they had courts in school. Do you remember that?
Yes.
I don't know why they don't do that anymore.
Well, I've had students, Deputy Lord, didn't we have about 50 high schoolers over here? 60 high schoolers. But I did do a tour with some young people and they were, I think, 4 or 5, over 100.
Wow.
But they were so well behaved, so I enjoyed it.
They're probably excited to see you, I'm sure.
So everyone, I'm going to call the docket. When I call the docket, let me know you are here. Please stand when your name is called. Kendall Smith is in custody. Tomas Lozano.
President of the Council.
Thank you. Alexander Streeter.
Good afternoon.
Good afternoon. Ralph Reyes. Ralph Divine Reyes Jr. Tamika Studemeyer. Hi, good seeing you. Omar Herrera, custody. Ashley Medina, custody. Jerry McGee, Johnny Della Rosa, James Ross, Cody Salazar, custody. John Ruben Magallanes. Thank you. Timothy Gonzalez. Timothy N. Gonzalez. All right, thank you. Santo Carcamo, custody. Troy Mishler.
He's president of council.
Thank you. Eric Padilla, custody. Joe Manuel Hernandez. Thank you. Juan Robles. Juan Jesus Robles Jr. Eric Padilla, custody. Luis Andres Persino.
Hey, Your Honors and counsel.
Thank you. Fräulein Guzman, custody. Craig Cantu. Dennis Pena, custody. Daniel Montoya. Thank you. Did I do that accent well? I feel as though I did that accent like I speak Spanish. Dennis Pena, custody. Jose Mejia. Deputy Mejia, did I do that last Mejia right? Custody. Guzman, custody. Alfaro Jonathan Lee, custody. Fernando Trujillo. Fernando Santos Trujillo.
Judge, I give you the paperwork. It's on.
All right.
Custody.
All right, thank you. Celeste Juarez. Makai Williams, custody. Jose Amador, custody. Jonathan Alfaro, custody. Zion Taylor. Zion Z. Taylor. Luis Beltran, custody. Christian Chavez. Thank you. Luis Beltran, custody. Jeremiah S. Miller. Jeremiah Miller.
That one came in this morning, Judge.
Thank you. Thank you.
Mhm.
John McNeil. John McNeil. All
That's going to be taken care of, Judge.
right, thank you. Alexander Patino. Kenneth Howie, custody. Aisha Esparza. Thank you. Marcy Martinez, custody. Sherry Cooper, custody. Kimberly Neto, Jose Amador, custody. Kevin Curell. Dennis Johnson. Thank you. Not the basketball player for the Celtics. All right. Is there anyone who came in late or your name was not called? All right, attorneys, we didn't have morning docket because I had to do a career, well, I didn't say have to do a career day, but I like doing the career day for the elementary children. Next time I have a career day, I'm taking a prosecutor and a defense attorney with me. So got my eyes on all of you. Please follow these rules and everything will run smoothly. If you have somebody in custody, ask the deputy to have them brought out. Once you requested them, please don't leave because for security reasons, we can only have a limited number of people in custody. If you have someone who wishes to speak in a language other than English, you'll need an interpreter. Let the coordinator know you need an interpreter. Once you've conferred with the state and conferred with your client, approach the clerk and just ask them to put your file up here. Please do not stare me down. I will call you in the order of appearance. If you are and you know what? I say that, Arlene, and people still stare me down. I'm like, stop mad dogging me. But anyway, if you have someone who's in the box and you're speaking with them, if we're on the record, that means I've called the style of the case. Do not talk behind the court reporter. Just raise your hand. I'll see you or the deputy will see you and they'll move you to the other end. Please do not approach the clerk or the coordinator when we're on the record because I'm trying to 100% focus on you and your client. All right, everyone, please confirm. Fernando Trujillo.
That's the one that's in federal custody and I did attach to you.
All right, thank you. Christian Chavez.
My case, Judge.
Yes.
We resolved the discovery. They uploaded the video. I just, I guess, a plea bargain deadline
All right.
or. I
And your
guess-
client's in custody, correct?
This one's on bond. He's present.
All right, Christian Chavez, come forward. State on Christian Chavez, I need an acknowledgement of discovery. And state that you tender an offer.
They haven't yet, Judge. We were waiting for this to,
All right, state you need to tender an offer off docket. And counsel, you have contact information for the state.
I do, yeah.
All right, so Miss, how old are you?
32,
Okay, you say that as though you're unsure.
31 going on 32.
All right. Okay, now you're going all Sound of Music on me. All right, Norma, on this case, if you can give me a 30-day reset for a plea deadline date, please. Thank you for dressing appropriately for court. They're going to give you a reset form. And what date, Norma?
1 second. I give you February 3rd.
All right.
Yeah, I'm sorry, March
3rd.
I'm looking at February date. Yeah, March.
All right, so you're going to be back on March 3rd. On that date, you'll need to let the court know whether or not you've reached an agreement. If you have not, your next date is going to be a jury trial date. And counsel, I know you have to be somewhere else. So if you'll make sure you get the acknowledgement of discovery.
I will.
And if you'll have a seat and they'll bring the reset form to you. Thank you for addressing
And
appropriately.
Judge, I'm gonna try to confirm my other one,
Okay,
but I don't know if we resolved the discovery stuff, but I'll let you know
all
shortly.
right, thank you.
I just go have a seat and I'll get you.
Yes, ma'am.
Yes.
There was a discovery that was, I mean, that was,
You guys try.
that was, so I'm just trying to correct it. So
Okay. All right, and which page is he on?
he was, on page 12, the first one,
All right.
so that one's going to be closed.
And what year is it from?
It's
Okay.
missing 88.
And who is Carol Barber? Attorneys, do any of you know an attorney named Carol Barber? I think that's before my time.
That's man,
Yes.
yeah.
Well,
That's.
I mean,
Well,
thanks for telling me
That's
that
way
part.
back in the day.
You know what? We have a case on the docket from 1986, but we're taking care of it.
Yeah. That's like when I first started practicing.
Yeah.
Plea bargain deadline.
These resume, deferred, discovery issues.
For senior opinion. He's here on honor and.
He's on. Yeah, he's here.
It was 3-3, right?
Yes, 3-3.
Yeah, you put two. Thank you.
Thank you, sorry about that.
And what page is Christian Chavez on?
Back. He's on page 9.
All right, thank you. Who's here on Luis Brasinho? Hey, how's it going?
It's going.
All right, did you talk to Bashan about the Pittsburgh Steelers? I don't mean that.
I don't want to talk about it.
Well, I mean, sometimes you need people who understand.
That old stuff,
On the next.
like we're
On the
past
next.
that already, okay?
On the next.
But we're not. So excuse me, everyone, could I have your attention, please? Could the Cowboys fans,
You know, okay.
Plug it
you're not-
out with
you're
the
gonna cost your
Pittsburgh
phone,
Steelers.
No, it could be, that's way worse. It could always be worse. Like, that's way worse.
okay, here we go. At some point, I think the Cowboys and the Steelers, you should be able to come together over your losses. I mean, as a Saints fan, I'm here for you all.
They have 15 years on this.
Yeah.
We're not. I saw some graphic where it was like teams in the NFC that have made the
Okay.
NFC champion. It was
I
like,
just tell
you
you-
on the page. Like,
I'm about to get held in contempt.
Yeah.
Well, Jerry Jones first, but then after that,
I
it's a
hear
bitter
you.
subject.
So on this one, there was an issue with discovery. Has that been taken care of?
it has not. And I checked it again. I checked it multiple times and again this morning, and there's literally not a thing for me to download.
All right, who's the state on Luis Andres Brasinho?
Sir, I don't know. So
All right, so we were here on December with this case for discovery. And last time we were here, defense attorney said no discovery was uploaded. And there's still no discovery. Where's the discovery?
It's uploaded to Verific, Your Honor. I don't know why defense counsel can't ask and can't access it. I advise defense counsel to inquire with their DAIT office to see if they can resolve the issue. If they can't, to provide me with a USB drive, and I'll copy all of it to her.
All right, are you able to provide him with a drive to copy the material?
I can't.
All right, so what I'm going to do is I'm going to recall this in 30 days for discovery and defense if you provide them with a drive, and also you can call and see why you can't see it on your end,
I'll
but
just give it a drive. I mean, it's not really bad.
all right, Norma, I need a 30-day reset for discovery. You may be excused. All right, we're going to come back in March 3rd, and are you still in school? Well, what happened with your school?
I'm currently in recovery.
Okay.
It's in the patient program.
Okay, all right, well, that's good. Okay, and make sure if you still want to go to school, you can still get out and start back at school, okay?
Yes, Your Honor, I already received my 30-day trip.
All right, awesome. Okay, well, I have, if you need anything as far as reporting by Zoom, because I don't want to interfere with his recovery or interfere with him being in school. You can appear by Zoom. Will they let you appear by Zoom?
If it's all right with you, Your Honor, I'd like to appear in person.
That's fine.
I think it said in the letter that you're supposed to be discharged on like February 21st.
Yes, yes.
So you should be out by then.
Okay, all right, so we're gonna recall you back for discovery on March 3rd, and it's, sure, March 4th.
Calendar.
All right, could everyone please whisper? Norma, on this case, if you can set it for March 4th,
Yes, ma'am.
is March 4th good for you?
Yes, Your Honor.
All right, so we're gonna bring you back on March 4th, and you're released from inpatient. Make sure that you stay vigilant about your sobriety, okay?
Yes, Your Honor.
All right, thank you for dressing appropriately for court. Once you sign the reset form, you'll be excused.
Thank you.
Thank you.
Have a seat.
Good afternoon, Mayor. May I please approach on Mr. John Manganianis? Yeah, with an M.
Hello? Thank you.
It's gonna approach when you have a,
Yes.
my input on my other case.
Mhm.
It's a plea bargain deadline, but I wanted to see if we could recall it for Monday so we could try to work it out. So I
All
can
right,
make
is
the.
this, John?
De La Rosa,
Maggia-
he's in custody. De La Rosa?
All right. Norma, if you can put, De La Rosa on Monday for disposition.
Yes, he's in
Yes.
custody. All right, thank you, Judge. I appreciate
You're
it.
welcome. Deputy Laura, you can take, De La Rosa back. Let him know his attorney had to be in a meeting. And, he can come back on, he's coming back on February 3rd.
Thank you.
See ya.
Right. John Magallanes,
Council President, Judge.
all right. Come forward, please.
Moving good.
All right, and has the plea taken place in county court?
It hasn't, they haven't filed the case yet, Judge. This is, the case is located in Impact 13. We're waiting on the state to file the case so we can go ahead and plead that one out.
All right, when is that going to be done?
I spoke to them this morning. I'm the attorney of record on that case.
Yes.
March 21st, we're coming back. They're either gonna dismiss it or they're gonna file it so that we can take a plea on it.
All right. So this is going to be the last date for something to be done with this case. It's a possession less than a gram. State, if you can help facilitate the misdemeanor court doing whatever they're going to do with their case, so this won't be taken care of,
Yes, Judge.
that would be greatly appreciated. Ms. Ferguson, I need a 30-day reset.
I can do March 4th.
All right, March 4th, and that's your final plea deadline date.
Our next hearing on the misdemeanor is on the 21st, March 21st. I guess we can, I'm sorry.
No need to apologize. I'm just trying to figure out why does it take so long?
I think as they haven't spoken to the complaining witness, that's what they told me today. So I asked if they could file it or do something with it, and they told me they're going to look into it.
All right, I'm gonna help them look into it.
Thank you, Judge.
All right, this is gonna be recalled back on February 18th. Norma, it's coming back on February 18th.
Yes, sir.
So, state, please speak with the prosecutors in misdemeanor court. Until then, this is coming back on February 18th.
Thank you, Judge.
Yes.
I appreciate
All
the
right,
court's
thank you.
time.
You're welcome. Thanks for dressing appropriately for court. Once you sign the reset form, you're excused.
I know you got this. Somebody's been acting a fool. I hope I'm never in a. Kindly, ma'am. I've been never in a position where you guys help me out. My whole life without that happening, to be a happy man.
Ralph Divine Reyes Jr. All right, you need to sit on the front row. Timothy Gonzalez. Timothy N. Gonzalez. Juan Jesus Robles Jr. All right, thank you. Fernando Trujillo, I have that, Norma.
Thank you.
Yes, ma'am.
Bye, have a good one.
Thank you, Judge. Oh, I apologize. May I be excused?
Yes, you may. Thank you.
Small window. It always does.
Norma on Trujillo,
Yes, ma'am.
put that for March. I'm sorry, put it for April 3rd.
Yes, ma'am.
Criminal Trial Division on Fernando Trujillo, that's being recalled for February 3rd. He has a, I'm sorry, April 3rd. He has a federal court's date scheduled in February for jury trial. You're welcome.
Hello.
I was going to ask him, I need to ask permission from her. It's okay with me. She.
I don't know, I know they get a motion.
I don't know.
You need to file a motion first
Right.
before she can grant it, so.
But I can just let her know what's going on so she can have.
Just a second. Yes.
On this one, Judge, she's back. We had a coach on the party for the face, and it was Scott Vincent. So he picked up a new case.
Mhm.
So, I think the state still needs to do their motion.
No, Scott said he was taking this up. Like Scott already talked to us about this a while back. Yeah.
Oh, okay.
Yeah, the new one?
Yeah.
So, but I mean, I think they need to make a motion before.
Yeah.
Yeah, so they need to make a motion.
But can you call Scott and see where he wants this set?
You can do
He
that.
might be in trial, if that's according to Lewis, he's in.
I talked to Haley last week, Haley called me on something else, and I know Scott's in trial this week.
Okay,
At least that was the indication I had last week. So let the court know.
okay, sure. All right.
I was. I was-
He's one of the few attorneys that I told my miss. I don't know.
Craig Cantu. Who's here on Craig Cantu?
I'm down. Morning, Judge, or
Morning.
afternoon.
So have you had a chance to confer with the state?
Yes, if we just, Monica just got appointed to the case 2 days ago, so the file's not here and we don't have any of the discovery yet.
State, why don't you have the file on Craig Cantu? This is family violence. The file on Craig Cantu, where is it?
I think it was an add-on to the docket, Your Honor, but the MAC appointed Monica out of order like 2 days ago
No, yeah,
or yesterday.
oh, maybe Tuesday. It was one of the cases. that
2
you
days.
Back to come down and reappoint.
2 days.
So,
So we haven't had the chance to get any of the videos or do anything. Monica has a visit scheduled with Mr. Conti for Sunday, so we're just hoping for a short reset to review the case.
recall this back on February 6th.
Thank you, Your Honor.
You're welcome.
You have a good afternoon.
You too.
Thank you. I said it now and then just send you them. Yeah, thank you.
As far as I know,
So talk to the judge on trials.
Michelin?
Michelin.
Michelin. Yeah.
And I'll stand.
Thank you.
Let me know.
I love her, but she's always running around. Downstairs, I just left her in the way.
Yeah, she's still here. All right, everyone, give me 5 minutes. Oh, see, everybody got quiet when I said, give me 5 minutes. I need to say that more often.
Very different. And I was like, and you can kind of do it when you have the no I have a little chart written out now about the things, like these types of. All right.
All right, everyone, please be seated. Troy Mishler,
Present, Your Honor.
and is the prosecutor for this. Ah,
There is a prosecutor that has the file.
Covering for 88 Samantha Brown.
okay.
She's in jury.
All right, just one moment. All right, where are we on discovery?
Received a call yesterday from Ms. Brown saying that there's new discovery in this case and that I would need to file a protective order to get it.
Okay.
I conferred with her outside just a little bit ago, Judge, when she had a break from jury duty to get a description of what I'm supposed to ask a protective order for.
Mhm.
I now know that where I can specifically file a protective order. That's one thing. The second thing, Judge, there's a new indictment as of either yesterday or the day before in this case. It's not new allegations. It's just
A
a
re-indictment.
rearranging of counts and paragraphs, but I don't have it. I'd like to take a look at it before I report to the court about where we are on
Okay,
the
and when
case.
was the new indictment?
Just a day or two ago, so it's brand new, and it's not changing the type of allegation, it's just making sure that the language was correct in the indictment, because there were some errors there.
All right, Norma, give me a reset for 30 days, and before this time, you'll need to have filed your motion for the protective order.
I will,
Okay,
absolutely, Judge.
We have those documents ready to give over.
All right, thank you.
I can do March sixth.
May I check my calendar,
Sure.
Judge, so that I don't have to whine to the court later on?
Sure.
March sixth. I'll be here, Judge.
All right, so we'll call it on March sixth. Thank you for dressing appropriately for court. Just have a seat and they'll bring the reset form to you. Okay. All right, so here's my question. Oh, you're excused. Just wait, he'll bring the reset form.
Thank you.
So here's my question for you.
Yes, ma'am.
I know that LSU, you know, you can call that, it's really Notre Dame's fault. But Texas A&M,
Yes.
I'm trying to figure out Texas A&M, why didn't they?
It's a question as old as the hills, Judge.
Is it a tale as old as time?
Our return on investment is not great.
Ah.
We're hoping for better return on investment. We're looking forward to March Madness and the College World Series, Judge. We have the
Okay.
number one baseball team in America going into.
Well,
the
we're gonna see what,
preseason.
we're gonna see what happens. Usually we're pretty good in baseball. We shall see.
Yes, and I have a,
There have been some complaints about gymnastics scoring, so I'm gonna have to see what that's about.
and I need to talk to you later about the great state of Louisiana,
All right.
because I have a high school senior that is very likely headed to Tulane.
Let me just tell you, we welcome everyone.
Even defense lawyers progeny. He's very excited. He was excited to get in, and we're looking
Oh, that is awesome. The Green Way.
the green way. They're asking for a green wave of tuition money,
Oh
but
my
we're
God.
working on that too.
It just keeps going up. And you know, I have some people who were in college with me and they were saying, I remember when tuition was $30 an hour. I'm like, I would love to go back there.
I'll get this signed, Judge, after I do maybe excused.
Yes,
It's
thank
good to
you.
see you.
All right, thank you.
Okay.
What page is Mishler on?
Just you. No, sir.
I need your partner for, I can put a reset. You can do it.
All right, excuse me. Who do we have here from the ROTC?
They're back there. Stand up.
Hi. So everyone, I always tell people, when you have visitors come to your house, and this is the legal world's house, we didn't have a chance to clean the baseboard, but we must be on our best behavior. So they're here to observe, to see how this legal system works. So please, when you see them, talk to them and tell them what you do. And thank you so much.
Thank you.
Yay. And Deputy Laura will show you certain things as well when she has a chance to, okay? All right, thank you all for coming down. Deputy Laura, you can have them come up front. You see them. All right, just give me a moment, right on. Hi. Hello. Hi, so what's your name?
Valeria.
And what's your name?
Jordan Bernardino.
Well, welcome to the 187th. You can always come in. So prosecutors are over here. They're usually the people who are sitting down, and there are prosecutors there. And the flower top sitting down, that's probation officer. And of course, the coordinator, Deputy Laura, and inmates. All right. So if you all would like, you can move about and just speak to some attorneys.
Okay.
Okay. So attorneys. So these are the two students who want to see how things run. So they're going to be moving about to speak to you. So please be kind and let them know whether or not this is a profession they should be in, which I'm sure all of you all will say yes. So don't be shy. You can move around and talk to the attorneys, okay?
Okay, thank you so
You're
much.
welcome. Okay. Aisha Esparza. Oh yeah, just walk around.
Oh,
Yeah, grab an attorney.
no, you're okay.
Todd. Okay, take care of the two students. Yes.
Thank you.
Are you all ready to proceed?
We're not yet asking the court for a contested setting.
All right. Who's the prosecutor?
I was hearing with Megan.
Okay. Megan. Where's she? Hi. All right, so they're requesting a contested hearing. All right, Ms. Ferguson. On this case, they're requesting a contested hearing. And if we could have 10 days.
10 days?
Yes,
Give me 1 second, Judge. Is she on board?
She's on.
yes.
I can do the 13th of February.
All right, February 13th is going to be your contested hearing.
Thank you.
Ms. Abrams, their contested hearing is going to be February 13th. And if you all determine that you all don't want a contested hearing, you need to let probation know
Will do, Judge.
enough time. Okay. All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you.
You're welcome.
Resolve and I'll let you know.
Someone say. They represent everybody.
We do.
Daniel Montoya. Who's here for Daniel Montoya?
Because.
Mr. Montoya? All right, so last time you were locked out of discovery, then he wasn't transported, so we had
Yes.
a lot of things. So-
Because we weren't sure if he was released or not. He is released.
Okay,
It was released to lifetime recovery
okay,
and he is in a program there. And they're the ones who transported him to court.
all right, so where are we on discovery?
I believe I have everything. I've conferred with the state today. They have made an offer to us. We have not made a counter offer to them yet.
All right, Ms. Ferguson,
Yes,
if
ma'am.
you can reset this for 3 weeks for a plea deadline date, please.
Yes, ma'am. I can do the 20th, February 20th.
February 20th?
I think that's gonna be a good date.
All right, your plea deadline date is February 20th. On that date, you need to let the court know whether or not you reached an agreement with the state. If not, your next court date will be your trial date. Do you understand?
Yes, ma'am, I understand.
Okay, all right, yes.
I wonder why is it so fast? I just got in county jail for 5 months and,
I know.
I don't keep cases on the docket that long. I try not to.
Okay, dear. You're good.
All right, thank you for dressing appropriately for court. Once you sign the reset form, you're excused. Oh, Norma, you said the plea deadline date on that, Kate, was when?
20.
All right, thank you.
Did you do this? Yeah. he's attorney.
Timothy Gonzalez. Hi.
Everybody's talking right there. I can't hear anything.
Oh, I know, and I'm screaming at the top of my lungs. All right, so on this case, where are we on the discovery?
We're good.
All right. Let's see. All right, was an offer tender?
There was.
All right, Ms. Ferguson, set this for a plea deadline date in 3 weeks.
There's also a co-defendant on this case.
I'm sorry?
There's a co-defendant on this case.
Okay.
It's not set on the same date. I don't know what's.
Oh, we'll make sure it's set on the same day.
Yeah.
What date?
February 20th.
All right, February 20th.
She said that like she did when it wasn't serious.
All right, thank you so much for
Everything else.
dressing appropriately for court. If you'll have a seat, your attorney will bring your reset form. Once you sign the reset form, you're excused.
Thank you.
You're welcome.
Thank you.
Yeah. It's been building up. That one's just the next step. The next is-
You could tell her. Yeah. Yeah, but it's just a jury's wrong. Is he on? No. Number 5. Number 5. I made it. That's for the insurance. That's water there. Yeah. You haven't separated. Yeah.
Earlier.
Separated.
Yeah, that's all there.
Alexander Streeter.
Judge Harahan?
Could we always have docket in the afternoon, then everybody shows?
It's just sort of surprising, so.
They were expecting lunch.
Maybe that's when we should move our docket.
That's what I'm wondering. All right. So is this a motion to revoke?
No, Judge, I think this is a motion for early termination. Is that right?
Yes, Judge, we were here back in June of last year. And the court was considering the early termination, and the court indicated that we should come back today and that you would strongly consider terminating him. I know the state is opposed, but I know probation is recommending it.
All right, I'll take evidence and we can go on the record. All right, court is calling 2020 CR 1544, State of Texas versus Alexander Bryant Streeter. Can I have parties announced for the record for the state?
Jason here, hand your honor.
Defense?
Judith Wimmer.
And are you Mr. Streeter?
I am, Your Honor.
All right, this is a request for early termination by the defense. Defense, you may proceed.
Thank you, Judge. We'd like to call probation, please.
All right.
Okay.
All right, have you conferred with probation before calling them?
Yes.
Okay, all right. Probation, can you raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
Bashan Abrams.
All right, defense.
Ms. Abrams, have you had an opportunity to review Mr. Streeter's probation history?
I have.
And has Mr. Streeter complied with all of his conditions of deferred adjudication?
He has.
Was he placed on probation in May, deferred adjudication, May of 2021 for 6 years?
Yes.
Does the probation department have a recommendation as to whether his deferred adjudication should be terminated?
At this point, they are recommending early termination.
I'll pass the witness.
All right, state.
No questions.
All right. I just have a few if there are no objections.
No, of course not.
Has there been any previous violations?
No, Judge.
All right. Any concerns?
No, Judge. He has no violations, no positive UAs. He's current on all of his fees. He's been cordial on all of his visits with his officer. He reports on time. The officer has no concerns at this time.
All right, thank you. Any further witnesses?
No, ma'am, we rest.
State, any witnesses?
No, your honor.
All right, I'd like to call the defendant if there are no objections.
No, ma'am.
Sure. State.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, what have you learned from being on probation?
Well, the severity of my actions was it resulted in the injury of a close friend of mine. Additionally, it damaged my relationship with members of my family and my community as well. The actions that I undertook were as a result of substance use as well, which was affecting my judgment. And every moment since then, I have taken that into consideration in my day. And my commitment, regardless of my circumstance, is and remains to conduct myself with integrity with regards to my personal choices and to avoid substances and discipline, as well as gratitude.
All right. And what classes were you required to take?
As part of my probationary agreements, I was placed on the UA hotline. And I had completed that, and then I was sent to a drug test. I believe it was monthly. That's the most recent thing I can remember.
All right. Any other questions?
Not from the defense.
Up on the state, your honor.
All right. Probation, and I forgot to ask this, part of his conditions was restitution. Was there any restitution amount that was owed? Did you pay me?
The defendant was never informed of any restitution.
Okay.
Please let me know if I miss.
Hey, it happens. All right, so no restitution is owed? All right, if there are no further witnesses from each court, will hear argument. Defense?
Thank you, Judge. The defendant has been on deferred adjudication for a little over 4 years. I'm sorry, almost 4 years. And I think he's been a very responsible probationer in satisfying all of the conditions of his probation.
All right, everyone, if you could please whisper.
I think that he's been a good model probationer. Given his youth and his comments just recently to the court, it appears that he has learned that the behavior he was involved in that led to this offense is not acceptable and can lead to severe consequences. And he has in fact changed his outlook on his personal behavior. Deferred adjudication is designed to have this kind of impact that if someone,
I'm sorry, just one moment. All right, I'm sorry. You may continue.
Thank you, Judge. So deferred adjudication is a process by which a probationer who does act appropriately, have no violations, and completes all their conditions to give them the benefit of early termination. And I believe that Mr. Streeter is a good representative of a person who should be granted an early termination.
All right, State, you are opposed. You may proceed.
Yes, Your Honor, those aggravated assault charge.
Okay. Just give me one moment, everyone. All right, thank you. Yes. Oh, this. Okay, all right. Okay. Is the 226 not available?
Nope.
Are they in a bench trial, jury trial?
Bench.
Okay.
They've come to the best.
Oh, look at you. Thank you. Look at you making my day. Telling me to push harder, Rashawn. That's all that's like. Push harder. We need you. All right.
It's a girl thing.
Let me just review something very quickly. Any objection to the court reviewing the stipulations?
Absolutely not.
All right. So state, have you had a chance to contact the complainants in this matter? All right, so this is what I'll do. I mean, he's completed everything and he's been on probation since 2021.
21.
And his deferred adjudication was for a total of 6 years. So we're already in 2025. The court will grant the motion, but the motion will not become effective until February 11th. State, will that give you enough time to reach out to the complainants? And are you on any type of GPS?
GPS, like an ankle tracker?
Yes.
No, Your Honor.
All right, so I'll grant your motion on February 11th. And that will give the state time to reach out to the complainants. I will tell you that part of my conditions for you on probation, and this was requested, I think, by the complainant as well, that there was to be no contact with Mr. Kloss, but no harm for injurious contact with Ms. Streeter. So the no contact with Mr. Kloss, you should probably still abide by that. Do you understand?
Absolutely.
All right. Is there anything else?
No, ma'am.
All right. Thank you.
May we be excused?
Yes.
Thank you.
And counsel, I don't know, did you file a motion or no?
I think that the probation office
You may
wanna did, I gave it was like- Is what you're asking for is an order?
Yes.
Okay, I'll get you one.
All right. Thank you.
I can read you mine.
See, yes,
It's a girl thing.
it is. Yes.
Judge, on your docket, you have a Eric Padilla. He has 3 cases.
Mhm.
2 cases Tony Hernandez is on. Apparently I'm on a 3rd case. I didn't know, but I'm asking the court if you can assign Tony to all 3, and he's okay with that.
All right. So if the client is okay with that, then of course it can be done.
Yes.
Okay.
I don't think he's out yet, Tony.
Oh, okay, sure. What page is Streeter on? Okay. All right, who's here on Beltron? And then to the officer, I will get to your file in just a moment. What? I don't know why this has sort of died. But just give me 1 second. This is doing something crazy. Odyssey.
Gotta love it.
Yeah, I mean, we have no choice. It's sort of like if you're a mom and somebody brings somebody new home that you don't approve of. It's like, if you like it, I love it. All right. On Beltran, who's the prosecutor? Where are we on this case?
Jason is, they've made an offer to us. We had an issue come up regarding a potential new case.
Yes.
My client wants to proceed to trial on this case, knowing that we have not gotten any discovery and it hasn't been indicted or he hasn't been arrested in the case. But my client still wants to move forward and have his trial.
All right, do you want a jury trial? All right.
And my understanding, it's the aggravated robbery is the case that, I don't want to speak for them, but I'm assuming that's the case. Jason, he has an abating and he has a possession.
All right, you both need to confer with Ms. Ferguson on a jury trial date and then come back and let me know what the jury trial date is. You'll be brought over dressed for trial in whatever civilian clothing you have. If you wish to be attired in something different, you'll need to do a clothing exchange with your attorney. If there's an issue with the clothing exchange, let the court know.
Never have a problem.
Okay. You know, other people come to me with these major problems.
I send the email and the letter, big print. And in the email, I tell them when I'm going to be there, what clothes I have to exchange. And sometimes they have it all done and I just have to go over there and exchange. Last time it was 15 minutes.
Oh, awesome.
But, you know, I don't know, maybe it's just, I go on Sundays, maybe that's it. Has
That's a good
something to
time
do
to
with
go.
God.
Yes. All right. They'll bring you back at that time. The court will not accept any plea bargain agreements without good cause. If you want to enter a plea and there's not good cause, you have to enter a plea open to the court. Do you understand?
Yes, Your Honor.
Okay.
Okay, good luck to you.
Thank you.
Norma, they're gonna, Jason and Miss Gay are gonna confer with you on a jury trial date. Who's here on, Jose Amador? On this case, do you have any witnesses?
No, Judge. He's reset and we're gonna go on his criminal history.
All right, court is calling. All right, everyone, don't whisper behind the court reporter. Court is calling 2024 CR 3037 and 2024 CR 3038, State of Texas versus Jose Amador. Can I have parties announced for the record for the state?
Orlando Castanon for defense.
And are you Jose Amador?
This one.
All right, we're here for sentencing. And 2024 CR 3037, you entered a plea of no contest to count 1 and count 2. The court found there was sufficient evidence to find you guilty. The court deferred finding of guilt as you've applied for deferred adjudication. According to the plea bargain agreement. This plea bargain agreement is off. Let me see. All right, we can go off the record. All right, so you all only went.
There was an issue in regards to one of the counts that they waived and abandoned, and that it was not a.
So I believe you only went on, initially we were going on council 1 through 4, and then after the court reviewed this, we waived 3 and 4, so usually we're only.
Yes. So on the plea bargain paperwork, if you all could initial, because it's still on there that you are proceeding on counts 1 and 4.
Judge, you're in the record with May 6th, the trial date?
I'm sorry, when?
May 6th.
That's Amador? All right.
No, Beltran.
Beltran.
That's Arlene Gay's client.
All right.
Thank you.
You're welcome.
And she can be excused, correct?
Yes.
Okay, I'll let her know.
Thank you. We're back on the record. So in cause number 2024 CR 3032, according to the plea bargain agreement, you entered a plea of no contest to counts 1 and count 2. The punishment is to be assessed at a cap of 4 years in the prison. The state is silent on your application for deferred adjudication, and there's a $2,000 fine. And there are cases that are running concurrently and some that are being taken in consideration. And then and cause number 2024 CR 3038. You entered a plea of no contest. The court found there was sufficient evidence to find you guilty. The court deferred finding of guilt. And that case is an evading. The other case is an aggravated assault with a deadly weapon. And in the evading case, your plea bargain agreement was for a cap of 4 years. There's a $2,000 fine, no application for community supervision. The state is silent on your application for deferred adjudication. This case is running concurrent with your other case. And also there are cases to be taken in consideration. Right. And in each case, defense, you waived the right for a PSI or TAP evaluation?
Yes, Judge.
All right. And the court requested that there be a criminal history provided for the court if there is a criminal history.
Judge, this is.
All right.
He has no criminal history, Judge.
All right. So state is silent. Defense, is there anything you wish to say? And of course, the most concerning thing is the aggravated assault with a
Yes,
deadly weapon.
Judge. So in this.
Just
instance-
1 second. Excuse me. Can't talk behind the court reporter. We're on the record. If y'all wish to communicate, ask the deputy and the deputy will move you when they have room. All right, defense.
So Judge, at the time, my client was 17 when he was arrested. This is a situation where he was with his mother. Vehicles brought to his home. They were on the way to go get some parts. In the process of driving, police were attempting to pull the vehicle over because they believed it was a stolen vehicle. He was not aware of that. There was 2 other individuals in that car with him. My client attempted to pull over. In the process of doing that, one of the passengers pulled out a gun and he freaked out. And so he then continued to travel on the highway, pulled up into a green belt. He was not driving at a very fast rate of speed. He went through a parking lot. He went through then a intersection very slowly, about 10 miles an hour. And as he did that, he clipped one vehicle with some civilians, and there was a unmarked police officer vehicle that hit him from the front to stop the vehicle. And so in that moment, he freaked out. He's very young. He's 17 years old, and he really didn't know what to do. He was kind of scared that something was going to happen, either that the police were going to shoot at them, or that this individual who he's not related to and was briefly acquainted with was in the vehicle with a gun and may do something. And so he panicked and he at that moment left and had continued driving. And so, because of his lack of criminal history, his age, that he should be given a chance to receive deferred adjudication and show the court that he's able to comply with those conditions and really to try and keep his record from having any felony convictions.
Oh,
Judge,
yes.
I know I'm silent, but I have reserved the right to speak to any inconsistencies in the
Yes.
past if I need. Just briefly, counsel had stated that, wasn't a long encounter and that he was driving slowly. And the evidence that was stipulated to the officer alleges that he was driving up to 100 miles per hour at one point. And it was a long process, like miles that was going on. And so I just wanted to clarify that for the record.
All right. So in the stipulations on page 7, it's of 7, Mr. Amador, it says, Jose Amador was traveling at speeds in excess of 100 miles per hour, weaving in and out of traffic, using the stolen Hyundai as a deadly weapon, crashing into a vehicle and 2 police vehicles. Jose Amador had a 12-year-old juvenile in the rear of the stolen vehicle, endangering her. And they said you used the stolen vehicle as a deadly weapon, trying to flee from the police, endangering, the people who were in the vehicle with you. And then that you did hit another vehicle and a patrol vehicle. So I don't understand. Why are you doing this? Do you wish to explain yourself?
Yes.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Salvador.
All right, so we're going to take this one step at a time because that's better for me so I can understand what's going on. So, first thing, they're saying that the vehicle was stolen. Were you aware of that?
No, ma'am.
All right, so I'm going to take, let's say you're not aware the vehicle is stolen. It appears that the police had their sirens on. Is that correct?
Yes, ma'am.
All right, so they get behind you, they have their sirens on. Did you think they were trying to pull you over?
Yes, ma'am.
All right, so they're trying to pull you over. Why didn't you pull over?
Because when I was trying to pull over, the passenger, which is my friend, I thought that was my friend, had threatened me with a gun, so that afraid of me, my life, and to like me being afraid.
Oh, so you're saying you were under duress. I think that's a defense if you're under duress. Am I wrong?
That's why we pled also no, understand that there's the risk that the jury may not buy into that defense.
Okay. So here's my other question then. Let's go back early in the day. You're in the vehicle, it's stolen. Did you pay for that vehicle?
No.
Did your mom pay for that vehicle?
No, ma'am.
So nobody paid for that vehicle. Did that vehicle belong to any of the passengers?
No, ma'am.
All right, so, yes.
I think an important question would be to ask him how that vehicle came to.
Oh, I mean, you can ask that question, Counsel.
So Mr. Amador.
Well, just one second. Let me finish and then you can. So you never paid for that vehicle. And how old were you when this happened?
17.
All right, so you're 17. You're in the vehicle with a 12-year-old juvenile in the back seat. What day of the week was this? Was it a Monday, a Tuesday, Wednesday, Thursday, Friday?
For sure.
All right, any objection to the court Googling what date this was?
No, Judge.
All right, so it was a Friday, according to Google. All right, and according to Google, that's that date, the only holiday that date was the Feast of the Immaculate Conception and the National Chocolate Brownie Day and National Christmas Tree Day and National Lard Day. So I'm assuming that those are not holidays that are recognized federally or locally where the school is closed. Is that correct?
Yes, ma'am.
So then why were you with a 12-year-old who wasn't in school?
I'm not too sure, but she's told me that she didn't have nothing to do with school.
A 12-year-old has nothing to do, isn't that
Yeah,
sixth
I
grade?
guess she dropped out. Not too sure.
All right,
But
so
she was
why,
still in school though?
well, why are you hanging out with a 12-year-old and you were 17 at this time?
Um,
And I'm just saying, usually 17-year-olds don't want to hang out with 12-year-olds. And then the other people were in the car. They say that they were juveniles also. How old were they?
I believe the juveniles were in the civilian vehicle that had been clipped.
That was it? Okay.
Yes, Judge. There were other people in the vehicle, other than the 12-year-old, were, in my understanding, adults.
Well, who else was in the car with you? So you have the 12-year-old who's the backseat passenger. Who else was in the vehicle with you? And I don't need the names, just,
and my friend.
okay, the 12-year-old was in the car with you, your mom was in the car with you, and your friend. And where was your mom sitting?
Back.
All right. And how old is your mom approximately during that time?
35, 36.
And just for my interest, is the 12-year-old any way related to you, your mom, or anyone else in that vehicle?
No, ma'am.
So your mom has a 12-year-old who should be in school and she's out joyriding with 12-year-old. All right, so while you are traveling 100 miles per hour and the police are behind you, what is your mom saying? And counsel, I know it's hearsay. I'm just trying to figure out what was going on in the car, if there was some kind of chaos.
She was telling me also to pull over,
Okay.
and I was trying to, but the girl had it. She had
Oh,
a
well,
gun,
did you
so
tell your mom, I can't pull over, the front seat passenger has a gun pulled on me?
She was afraid too. My mom, she couldn't do nothing.
No, you said your mom told you to pull over. So did you tell your mom the front seat passenger has a gun, I can't pull over?
No,
Okay. All right, so you're driving 100 miles per hour, you're not pulling over. So when did this end? What caused this all to end? Was it the crash?
yes, ma'am.
All right, so the crash happens, and what happens to the 12-year-old in the back seat and your mom?
They get arrested.
All right, and what happens to the front passenger?
She gets arrested too.
Okay. All right, you have clarifications?
Yes, so did you know the person was 12 years old?
When I first met her, no.
Okay, and how did you end up driving that vehicle? Who brought that vehicle to you?
The 12-year-old.
Okay, and you thought the 12-year-old, the car belonged to her?
Yeah, it belonged to her parents.
And were y'all joyriding that day, or what was the purpose of driving?
I had to go get parts to fix my car,
Okay, and where were you going to get those parts?
to a junkyard.
There's some clarification in regards to how that.
Oh, I have more clarification. So you're telling me a 12-year-old comes to you driving a vehicle and you have no questions about that as a 17-year-old?
Yes, ma'am. I mean,
And your mom had no questions? So how do you end up driving the vehicle? Did the 12-year-old just throw you the keys? I don't understand.
I mean, she didn't have no keys there. Yeah, the car was on already by the time she went to my house. I just hopped on it. I thought she had it like a little remote, I thought it was a push and start. So that caused me like thinking that was her parents' car.
But why would you drive if she's coming over to your house?
Cause I saw that she was like, I felt like she was young. Cause
All
when I
right, and
met
was
her,
this a planned meetup? Did she call you and say, hey, I'm coming over?
no, I asked her if I can borrow one of her parents' car. And she said it was fine, so.
All right, this story is getting a little bit off track, and it's, well,
Judge,
when I
if I
say
may,
off track,
I
it's.
believe that the 12-year-old, she's a juvenile, but I think she also has subsequently been arrested for unauthorized use of her vehicle.
Okay. All right, any questions from the state based upon the answers that the court has received?
So Mr. You stated that you didn't know that that vehicle was stolen, correct? But when you began to drive it that day, I mean, you had to have seen that the door handles were broken off, correct?
Yes, ma'am.
And so that didn't indicate to you that something was off with that vehicle?
No, I mean, there's some vehicles have broken handles too.
So you think that's just normal?
No,
Okay, and it didn't have keys to operate it, so how was the vehicle started and how were you operating it?
I don't know how she started it.
What was in the ignition when you were operating the motor vehicle?
I'm not too sure.
And so you stated that you were under duress because the juvenile, or that you felt that your life was being threatened because the juvenile had a gun, is that correct? Is that your testimony?
Yes.
Okay, and so, and the evidence that was stipulated to, which is the police report, Sheriff Deputy with the Garrett County Sheriff's Office states that she observed you crash into a marked SAPD patrol car and continue going. So if you were scared for your life, don't you think that that was a good time to, you crash to maybe notify police that you were scared and that the juvenile had a gun? Right? And so after that, you continued on to crash into the motor vehicle that had the juveniles in it, correct? And then in this police report, it states that after you had already crashed into those two cars, officer heard you accelerate on the gas to get through the SAPD Marked Patrol Unit and a court order, and that you proceeded straight for the Bear County Sheriff's Office Marked Patrol Unit, which had the lights flashing, and proceeded to crash into it so hard that the officer's body worn camera fell off. And then you still didn't stop, correct?
Correct.
And you don't think that would have been a good time to maybe notify police that your juvenile had a gun and that you were scared?
Yes.
It would have, right? And then after you get in a crash and you stop, you still don't comply with the police, correct?
Correct.
You take off evading, right?
Yes.
And ultimately, you don't even stop, you have to deploy the
Yep.
taser on
Judge,
you,
at this
correct?
point, I'm gonna have to object that I don't believe the state's remaining silent. This goes outside of the scope of, I believe, what our question was.
All right, with regards to the question about the, you said tasing or something?
Yes, right.
All right, so that objection will be sustained. I think it's going beyond the facts or beyond the scope of my questioning and the defense's questioning and whether or not he is being dishonest.
I understand, but it was just going to, their assertion about the juvenile, but I understand. Thank you.
All right, counsel, anything else?
No, Judge.
Anything else you wish to say? All right. In each of the cause number, the court is going to deny your application. Defense, you want to speak towards the cap?
Judge, just that he's a young individual, he's never been in trouble before. This is obviously entering a conviction on his record is going to do a great deal of damage just towards his life. And we ask that you consider the minimum in this case.
All right, and cause number 2024 CR 3037. Court will find you guilty in count 1 and count 2. Count 1 and count 2 will run concurrently. The court will sentence you to 3 years in each count. Give you credit for any time served. There's a $2,000 fine. Time and money to run concurrent. This will run concurrent with 2024 CR 3038. And state will take in consideration 2024 CR 2939 and 2024 CR 3039. Is there any objection to me changing what is running concurrently? Because there's still count 3 and count 4 listed. All right,
No objection to that.
thank you. I just don't want there to be a mistake. All right, and that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
And I'm so sorry, in that cause number, there's also an affirmative finding of deadly weapon. And cause number 2024 CR 3038. The court is finding you guilty. The court will sentence you to 3 years in the prison. Give you credit for any time served. There's a $2,000 fine. Time and money will run concurrent. This will run concurrent with 2024 CR 3037. Taking consideration 2024 CR 2939 and 2024 CR 3039. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, you have something for me? And we can go off the record. Here's the thing, I understand that there are some issues going on in your life because your mother should never have been in that vehicle with you. Your mother knew that that was a 12-year-old who should have been in school. So I understand that you have a hard life. But this is what you're gonna have to do. You're gonna have to find in yourself what is right, what is wrong, because it appears that your mom is not that person to instruct you. You understand? So when you get out of prison, do not become one of those people who becomes institutionalized. Do not go to prison and get all these prison tattoos. If something happens and you must get a tattoo, don't get a tattoo on the face. Don't get the teardrops. Don't do any of that. Because when you get out of prison, when people see teardrops and all these other facial tattoos, they know it's prison tattoos, and then they don't want to read you know, the book. They're looking at the cover. So you still can do something with your life. You're young. They have free education at the prison. You can even get a degree at the prison. You understand?
Yes, ma'am.
All right, good luck to you. And when you get out, if you need anything, I'm still here. Come back and I'll help you out, okay?
Thank you.
You're welcome. All right. Carcamona, I'm sorry, Carcamo.
Hernandez? Can you put Joe Hernandez? please?
Hello.
Sharing.
So what is happening with this case?
It's on the.
But I think we're just, we received a plea offer today. And judge, just for the court's information, I'm here for Mr. Locke. He was stuck in Del Rio.
Okay,
So I have not had an opportunity to communicate with the client. Mr. Locke speaks Spanish. I do not.
okay. So the offer was tendered.
Yes, judge.
Okay. All right, and my understanding is that you all would address the immigration issues. All right. So Norma, recall this. How old are you, sir?
25.
All right, Ms. Ferguson, call this in 1 month for a plea deadline date.
Oh, yes, I might give you March 6th.
All right, your plea deadline date is March 6th. On that date, you'll need to let the court know whether or not you are accepting the state's offer. If you all cannot reach an agreement on that day, your plea deadline date will have expired. The court will not accept any plea bargain agreements without good cause. Otherwise, you have to plead open to the court. Do you understand?
Yes.
All right, do you have any questions, sir?
No.
All right, thank you. Who is here on Alexander Patino?
Tony Hernandez. Tony Hernandez. Santo. Toma asiento, por favor.
Court is calling 2024 CR 10692, State versus Alexander Patino. Can I have parties announced for the record, for the state,
Jason Garahan, Your Honor.
for the defense?
Chelsea Sepulveda.
And are you Mr. Patino?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? And did you understand it?
Yes, ma'am.
Are you the same Alexander Patino who was placed on community supervision in 2014 CR 10692
Yes, ma'am.
for the offense of injury of the child with intentional bodily injury on November 15, 2019 for a term of 10 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor, violated condition of law for about the 9 days, December 2024. We did find text. Been a house and it's been a bit of a without stated violation condition.
How do you plead to that? True or not true?
True.
A good way to make violation.
Any objections to the waiver?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 10 years in the prison? Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, and it is to deny the motion to adjudicate. Any of the individual is deferred. With the understanding he is going to, the mission report later to include the WI. Also to add conditions to this case, defensive driving, obtain a TAP evaluation, intensive outpatient treatment, DWI education, VIP live.
All right, I'm so sorry. Let's go off the record for a moment.
He is already on.
Yes,
probation.
he's already on
Oh, I'm sorry.
regular supervision. Yes.
Here, I said it you, that's what I said on this one.
Okay, yes. So he's on probation for 10 years with the underlying sentence of 10 years. So you want to deny the motion, alternate amend conditions to include?
Yes, Your Honor.
And I'm sorry, could you repeat?
Yeah. Is it back on the record? Judge?
Yes, we're back on the record.
So, yeah, Judge, actually, it's deny the motion to revoke, continue it on the probation. With including defensive driving condition, TAP evaluation be obtained, intensive outpatient treatment, DWI education, VIP live, monthly UAs, sober support meetings, and then also to add the ignition and the lock.
All right, is that your proposed agreement?
Yeah, sure.
Are you asking the court to follow that?
We are, Your Honor, please. My client's been on since 2019. He's apparently have two children, a 2-year-old and a 15-year-old. He had not seen them for quite some time. I think he was going through a bout of, or an episode of depression. He made a mistake. He's remorseful for that mistake. He's willing to do whatever the court orders him to do, and he's expressed that he will not be back in court again if you allow him to complete those classes. He's just asking for an opportunity to satisfy the probation and get this behind him.
All right, probation? Yes, sir. What is the recommendation? All right. Then the court will deny the motion, alternate amend conditions to include defensive driving. We'll need an updated TAP evaluation, DWI education course, VIP live, monthly UAs, ignition interlock until further notice, 120 sober meeting, 120 sober meetings in 120 days. And we'll do a MIC evaluation that can be done out of custody. Is there anything else, probation? Let's see what the TAP evaluation recommends. If TAP recommends inpatient treatment, we'll start with intensive outpatient treatment. If they recommend outpatient treatment, we're going to still start with intensive outpatient treatment. And the reason why I'm doing intensive outpatient treatment, because you knew you could potentially be going to prison for 10 years. You're not allowed to drink while you're on probation at all. And you still made the choice to drink. You understand?
Yes.
All right. Is there anything else you need from the court to be successful?
I believe that these courses will, I've already started looking into other classes as well. But I believe these will help.
All right. And if there's something else you need, let the court know. That's what probation is here for. The state agree with your attorney to place you on probation. So everybody wants you to be successful, but we can't help you if you don't let probation know what's going on in your life and that you need extra help. You understand?
Yes, ma'am.
All right. Good luck to you. Thank you for dressing appropriately for court. Yes, ignition interlock until further notice.
It would be excused, Your Honor.
Yes. Well, he needs to speak with probation.
May I be excused?
Yes. Celeste Juarez. Yes. And to the officer who's waiting, I just have 4 more cases and then I'll take up your matter. Where are we on discovery?
Judge, we are still missing discovery.
What are you missing?
There is what we would call an IDR. The SAISD is calling it a CAD. I think in essence, it's the same thing. We don't have it.
State?
Messenger, Crystal covering for Samantha Brown. It's my understanding that it was asked if the SAISD had a, what is work, normally called an IDR, and they don't have it. They have more sort of a CAD system wide, I think. I know that our investigator has put in that request. He's out today, so we don't have an answer on that, but that request has been made for that specific piece of discovery.
All right, so this is what I'm gonna remind everybody. This discovery that you all been having has been going on since September. So I'm gonna give you one final date for discovery, and let me just tell everybody what's gonna happen. If you know that you don't have what you need to let the state know, and state, you need to subpoena whomever is supposed to have it, and they need to come into court and explain why they don't have it. All right. Ms. Ferguson,
Yes, ma'am.
recall this for the end of February for discovery.
Yes, ma'am. The 20 I can do the 27th.
All right, that's going to be the final discovery date.
Thank you, Judge.
All right, thank you for dressing appropriately for court. You can have a seat. Your attorney will bring you the reset form, and then you will be excused once you sign it.
Yes, ma'am. Thank you. I hope you had a good holiday.
Oh, thank you.
It's just a quick question. I
Yes.
know defense did state today, and I know it's been previously filed, but is there a motion for discovery and inspection specific ones? Would that be heard at that hearing date as well? Did the
Sure, unless there's something that needs to be seen now.
Judge, I've talked with with Samantha Brown, who is the prosecutor handling this case that can't be here today. She's asked that we not urge that today because she wants to take a deeper look at that. We don't have a problem with waiting until the next hearing out of respect for
Okay.
Ms. Brown.
All right, thank
that
you.
date as well? Let her
Yes.
know. Thank you, Your Honor.
You're welcome.
Maybe excuse?
Yes, thank you.
Have a great day.
You too. Who's here on Tamika Studemeyer? All right, so do we all, oh, is she in here? All right, I'll wait for you to get her back. Kevin Curell. Who's the attorney for Kevin Curell?
Todd just stepped out, Judge.
All right, we'll wait for that. Ashley Medina. Thank you. Court is calling 2024 CR 007345 State versus Ashley Nicole Medina. Can I have parties announced for the record for the state? Defense?
Thomas Beck.
And are you Miss Medina?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Are there any applications?
Yes, Judge. Probation.
Okay, let me see.
Oh, get the bill back out.
I do not have an application for probation.
Sorry about that, Judge.
Oh, that's okay. Yes. All right, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, sir.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with the offense of driving while intoxicated with a child under 15 as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand? If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do so believe.
Ms. Medina, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is recommending 2 years in the state jail facility. There's a $500 fine. State recommends community supervision and ignition interlock for half the term. Did you understand that to be your agreement?
Yes, ma'am.
Defense, is that the agreement?
It is, Judge. We're hoping that you'll probate the fine,
All right.
but that is the agreement.
State, is that the agreement?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be a TAP evaluation, community service hours, and parenting classes and the DOEP course and regular UAs. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
No objection.
All right, state, you may be excused. Did you review the waiver and consents with your attorneys? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, she obviously was taking drugs and she's very motivated. She's changed totally, but she's been incarcerated. And she wants to make this probation and solve her drug problem.
So what were you thinking?
I clearly wasn't thinking, and I had a lot of time to think about it, and I do regret what I did. I have remorse for everything. I've known better than that, and I was just going through a really difficult time for the last couple of months before that happened, and it's no excuse, but I was bad judgment, and I do apologize for it.
Is Child Protection Services involved?
I had a case, but I got it closed.
Okay, let's unpack that a little bit. When you say you got it closed, obviously you're in custody. There's no way they will return your child to you because you're in custody. So what happened?
Well, when this first happened, I did get a case, but I did the classes and I did the drug test and I was able to get that case closed.
Well, so why are you in custody?
I had a warrant.
She couldn't make bond.
All right, so did they pick her up on the same day that this happened? Because the offense date for this is May 9th, 2023.
Yeah.
So you've been in custody since May 9th?
No.
All right, so,
Dismiss the case. For further investigation and re-brought it. I think that's what happened.
State, is this a case that was dismissed and re-indicted?
Do not know the answer to that question, Your Honor.
Definitely wasn't. I can show you the print. Computer print.
Okay, I'm looking up now through.
For the record, it's Megan Galloway. So this case was dismissed in April of the same year of last year, and the dismissal was re-entered again in November with the same April date, but it was indicted before that November date that you see in your computer. So I don't know if there's a clerical error of them entering the dismissal again in November, but if you look at the dismissal that's scanned in the system, it has an execution date of April. And so
For the dismissal of the case?
yes, so it was dismissed in April for further investigation. And then it was indicted again once we got the toxicology results
okay.
back. And then for some reason, that dismissal that was submitted in April was entered into the system again, but no new dismissal was submitted to the court.
Okay. All right, that explains things. So are you employed?
Not currently, but I'm very sure I can get a job as soon as I.
Doing what?
I'm sorry?
Doing what?
Anything that I can to make money, until I find something I enjoy doing.
I'm sorry, what?
I can do anything, until I get somewhere I want to be. I've worked in a lot of places, so I have a lot of experience and I'm willing to do whatever I need to.
All right, everyone, you need to whisper so that I can hear. All right. The court is going to sentence you to 2 years in the state jail facility, suspended and probated for 4 years. In custody, this is what I want done. I want a TAP evaluation. Follow TAP recommendations. Proof of employment within 30 days of release. There's to be no employment as a home healthcare provider or with minors. Ignition interlock for half the term. How far did you go in school?
I graduated and I was a dental assistant.
All right, there's going to be 200 hours of community service restitution. Parenting classes and probation. If she completed parenting classes as a part of this case, then the court will deem it satisfied. There's to be regular reporting by Zoom or in person, regular random UAs. And I'm going to order the DWI education course and Victim Impact Panel Live. And I'm going to order 1 year license suspension. State, is there any restitution to the complainants?
Judge, it's to be determined.
All right, so counsel, I think there's gonna be a restitution amount because there's a school bus involved from my reading of things. So what we'll do, if there's an issue with the restitution, we'll set it for a restitution hearing. All right, so there'll be restitution, if any. And that will be to her daughter who was in the vehicle with her. And also they don't have the names of the children on the school bus, but so that the record is clear, the driver of the school bus was a Mr. Abonce or Abonce, A-B-O-N-C-E. So it's him and the 21 students who are on the bus. And there's going to be field visits 1 time per month until further notice. Probation, is there anything else? Okay. Is there anything else you need from the court to be successful?
No.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, You do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
Thank you, Judge.
Thank you. And everyone, just give me 5 minutes to read this document. And Ron Ross is in the waiting room. I don't know who he's here to speak to. All right, can I see the officer, please? Who's the officer on this? All right, thank you. If you'll come this way. You solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God. All right, you can lower your hand and you'll state your name. It's all right. You can lower your hand and you can sign. Oh, it's a long day.
Yeah, I saw your one when you were gonna try to go somewhere else, but so you have to do it for the point.
Oh, yes, thank you. Well, it is. And then anytime I have to go, things get complicated. You too. Kevin Carell? Yes. I know it's somewhere in this stack if I have it. I'm going through. Yes.
It is the,
And this is for sentencing, correct?
Correct. Yes, Your Honor.
All right, court is calling 2024 CR 3419, State of Texas versus Kevin Carell. Can I have parties announced for the record for the state? Defense?
Jason Todd for Mr. Carell.
And are you Mr. Carell?
That's right.
All right, you entered a plea of no contest on October 17th. According to the plea bargain agreement, the state was proceeding on counts 1 and count 2. Is that correct?
I don't recall, Your Honor. May I look at the counts just to be sure?
Yes, because I don't have it listed that way.
And that's not typically how. But I understand.
Here's the indictment.
I remember now. I believe there's two victims, and that is correct, Your Honor. I
Okay,
apologize
yeah.
for that delay.
Problem. All right, so you entered a plea of no contest to both counts 1 and 2. According to the plea bargain agreement, punishment is to be assessed at 5 years. There's a $2,500 fine. State is silent on your application for deferred. The state recommends community supervision, and there's to be restitution to the complainants. Did you understand that to be the plea?
Yes, Your Honor, that is what we understood.
All right. So we are here for sentencing. The state is in agreement to your having supervision, which is a conviction, but they're silent on your application for deferred. So let's get to the crux of this situation. Why should I give you deferred adjudication? Counsel?
Your Honor, we've given a mitigation packet to you to talk about Mr. Curiel. That's been given to the state. The state reviewed that before they give that to you. Judge, we come to you today to first of all accept responsibility, but also to give an explanation. The first part of this is Mr. Curiel is he works very hard. He has family members that depend on him. He does have a prior drug offense that I believe is a marijuana offense. So I can't say that he has no criminal history, but he has a very limited criminal history and is an active member of this community. What we're after, the reason for the deferred is to allow him to continue working in his business and in his job and supporting the people around him. The difference between, as you know, a conviction and not a conviction is significant. We do have an explanation for the night. Once again, not to put off any responsibility, but just to explain why Mr. Curiel reacted the way he did, albeit inappropriate if the court would care to hear.
All right, yes.
Judge, what I'm presenting to you, in the end, Mr. Curiel was afraid. We understand that this was a scene in which many people were upset. If what I'm presenting to you now, Judge, the first is a dialogue from the 911 call. The second is the police report from that night. And then the third set are pictures of Mr. Curiel. What it shows is that people were upset at the scene. And then Mr. Curiel was disorientated. When he says, from the moment that I've met Mr. Curiel, he said he left because he was afraid. Our question to him, and the question from the state, which is a very fair question, is why didn't you wait for the police? He doesn't remember the police being there when he left. We went through and I've shown him evidence that shows that it looks like they were there, that he could have waited, that he didn't have to leave. What we're hoping for you to see, Judge, that he had a reason to be afraid. And he made a poor choice. He should have been more patient. He should have stuck around. There's other things he could have done besides leave. We have two more exhibits, Your Honor, that the state object to. They haven't objected to any of these that I've shown you so far. That we believe we know who Mr. Leal is. We believe that we found who he is, and he has a criminal history. What we're just trying to do to suggest is that Mr. Curiel had a reason to be afraid that is not unreasonable, especially at a scene where people are upset. It's our understanding that Mr. Moses Leal is a family member of the victim, and we understand why he would come to the scene upset. So once again, we're not trying to put off any responsibility. We're just trying to give an explanation. If you want to talk to Mr. Curiel, he is ready to speak to this as well. We just hope that in some way mitigates his choices. Additionally, Your Honor, we have the claim information regarding this case, that this case is settled. I'm going to jump ahead of the state. The state has brought you is going to give you additional restitution. We're not going to object to that. All we would ask for is just time to pay. We weren't expecting that today. We just found that out today. We have no objection to it being included. And I know that Mr. Curiel, I've advised him that he's ready to resolve that as fast as he can. It's just not something that he has at this moment.
And Your Honor, if I may.
Yes.
Apologies to defense counsel. I did not become aware of this particular document until this afternoon.
Okay.
And that's fair, Your Honor.
Is there anything you wish to say? You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Kevin Creel.
All right, so how old are you?
I'm 40 years old.
How old were you then?
I have been 37.
All right, and how long had you been a driver when you were 37? How many years?
CDL driver, 9 years. Driver's license since I was 16.
All right, so then you know, especially with a CDL, if there's an accident, you have to stop.
And render it.
Yes.
Yes, ma'am.
So why didn't you do that in this case?
Well, let me start. When the accident occurred, it was my fault. I was having an argument with the passenger, took my eyes off the road. I caused an accident. When I did, my first reaction, check on passenger, I got out and I walked to the victim's vehicle. Are you okay? Is everybody okay? Hold on, 911's been called. And that's when I was met with a man without a shirt. And that's where everything just took a twist. I was scared. I admit I should have waited. So I didn't know that the cops were there. My attorney has shown me evidence that it suggests that there was police there. I didn't know and I left. If the police were there, I 100% should have waited. And it was a rough night.
Any other questions? Any questions?
State your own.
All right, and the court will note for the record, the court has reviewed the police transcription 911 call, which seems to corroborate what the witness is saying as it relates to someone approaching him. And I want everyone to know I can understand someone approaching someone in anger when there's an accident and your loved one is injured. And by the same token, I understand if someone is being approached in anger at an accident. And from the photos that were admitted to the court to review, the defendant was injured as well. I just don't see what would be the justice, I guess, for want of a better term, and giving him a conviction where if he has the deferred adjudication, he is looking at the full range of punishment. So is there anything that I'm missing that would suggest to the court that Mr. Curiel should not have deferred?
Nothing from the defense, Your Honor.
Here you go. And I'm basing my decision on granting his application based upon the mitigation packet that's been submitted to the court and based upon the stipulations that have been given to the court as well. So with regards to sentencing, this is what the court will do. And counsel, I'm going to return to you the 911 call and the conversations that were recorded and that were transcribed.
Thank you, Judge.
So counts 1 and counts 2 were run concurrent. Do you have a suggestion for length of deferred? And I'm expecting everyone to be reasonable. And do you have any objection, even though the state is silent, do you have any objection? I know they're silent on your application for deferred. I am granting your application for deferred. They're asking that your community supervision be for a term of 10 years. So state, I'm assuming that you are asking for the deferred to be for what length of time?
10 years, Your Honor.
All right, so they're asking for 10 years.
Judge, we would ask for 5. We believe that in that time, he'll show the court who he is, and if it'll happen, it will become clear very soon if he's able to do it, and then he'll have the full range available regardless of how long the term is.
All right, this is what I'm gonna do.
Your Honor, may I briefly respond?
Yes.
The state would prefer the court to impose 10 years of deferred adjudication because if, as defense counsel claims, Mr. Curio shows the court who he is and abides by his requirements, then he should be able to come to the court and request to be terminated early from supervision.
That's correct.
Okay. Then we will do it for 10 years. All right. Court is going to sentence you to 10 years deferred adjudication. There's to be regular reporting by Zoom or in person, $2,500 fine, time and money to run concurrent, 200 hours of community service restitution, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. The defensive driving course. There's to be restitution, if any, to Maria Sanchez and Inez Leal. Field visits one time per month for 6 months. Regular random UAs. And you can either do the regular random UAs or you can do a patch. The patch costs more, but it gives you more abilities for employment. TAP evaluation, out of custody, and follow recommendations of TAP. Probation, is there anything else?
The tax evaluation already been complete. The recommendation was with your analysis.
All right, then that'll be the DOEP course. Is there anything else, probation?
Okay.
Is there anything else you need from the court to be successful?
Yeah.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, we can go off the record. Here's the thing, in this court, to be successful on probation, communication is key. If there's an issue, you need to let probation know. If you feel as though they're not addressing it, you can always come back to the court. Do you understand?
Yes, sir.
Counsel, is there any victim impact?
Yes, Your Honor.
All right, Ms. Leal? If you could unmute for me, please.
Yes, Your Honor, I'm here.
All right, Ms. Leal, it's the court's understanding that you would like to have a victim impact statement.
Yes, ma'am.
All right, you may proceed.
Okay,
Oh,
hi,
I'm so
my name
sorry. Before you do that, also, there's going to be a restitution hearing.
Okay.
Ms. Ferguson, can I have a 30-day reset for a restitution hearing?
March 4th.
All right, Ms. Leal, the restitution hearing is going to be March 4th. Whatever documentation you have, be sure to tender that to the state, and you'll be allowed to appear for the restitution hearing by Zoom. No objections, I'm assuming?
No objections, Your Honor.
All right, you may proceed, Ms. Leal.
Hi, my name is Inez Leal. I am, the reason for the impact statement is I am in agreement with everything that y'all have for the sentencing part. And thank you so much for giving them the 10 years deferred. And the reason why I want the 10 years deferred is because he didn't acknowledge us. Yes, my brother was upset. He was very upset because I was screaming in so much pain, and not once did he acknowledge us. And that is the only reason why I am angry. Still angry, because there was 3 females in the vehicle. It wasn't a car full of men or young kids or anything. I'm an old lady with two young girls. Like, he did not acknowledge us. So I just want to say that part. Second is, I didn't know the extent of my injuries. Now, after the wreck, I needed surgery, and I have 6 screws and 2 rods. Before that, I was working 6 days a week, 10 to 15 hours a day, 6 days a week, supporting my family. And now I'm not able to work. I want to work. Having to be at home now. I'm sitting here, I'm going and a little bit over a year trying to get disability, trying to get Social Security. I'm behind all my bills, like since the wreck. And like I'm glad he got hurt too, but it was his fault. And I'm glad that he's acknowledging that it was his fault. Now, the thing is that I'm disabled permanently for the rest of my life, and I'm still young. And my grandkids are coming. I can't even enjoy parties, barbecues. And I'm literally not making none of this up. If I could work right now, and I want to work right now, but my body does not let me work. And so now my two youngest ones, my third one already turned 18, so he's grown. He can start working or whatnot. But my two younger ones are the ones that are hurting because those are the ones that I should be. When I was working, I was spoiling my older ones. But now that it's coming, I'm trying to keep this brief. But my two younger ones, now that I'm supposed to be spoiling because I've already spoiled the three older ones when I was working, and now I'm not able to work. Now I'm gonna have to sit here and live on a set income that I'm not ready for. I don't want to live off of 900 a month and then whatever Social Security decides to send me or whatnot. So that's the reason for the restitution, because you're gonna get to work, you're gonna get to enjoy your family outings with your kids or whatnot. But what about me? I'm sitting here disabled for the rest of my life. I got 6 screws and 2 rods. I'm waiting to get surgery on my lower back. Like, guy, you made a bad choice, and it's affecting you. But you're still getting to enjoy life, and I'm not. And my kids are not, or my grandkids are not. Like, you made a bad choice and you messed up my life. Because I was that woman, that single mother for the past 12 years that wanted to go work. I didn't care about child support. I didn't want no child support. I could care less if he owes me that. The kid's dad owes me that for the rest of his life or whatnot. I didn't care. I didn't want to depend on that. So I went out and busted my butt to sit there and support my kids and have a roof over their head and get them what they wanted, what they needed, and then some of what they wanted. And now I'm sitting here waiting for a darn check that I still haven't got. And behind my bills, I didn't get my kids nothing for Christmas. Nothing for Christmas because I have nothing. Like, you just don't know it. I don't know why I can't see you. I wish I could have seen you. I can't even see you in the video or when I wish you could see me, the pain that you've caused me and my family. And this is for the rest of my life. Okay, I'm sorry. I'm trying to keep it brief. I have a lot more to say. I have just so much anger for the way that I'm stuck now for the rest of my life. But thank you. And thank you for sentencing for the 10 years. That's just what I wanted. I did. I'm sorry that I know he has no priors except for whatever I heard, the marijuana or whatnot. But what do you call it? I'm very, because I want him to remember for at least 10 years that you've ruined my life, that you're going to have to go report and do what you got to do so you can remember me, instead of you doing this for 5 years and then for you to sit there and after that, you're going to be, oh, happy-go-lucky and, oh, let's party. We're done with the fight. No. 10 years, guy, 10 years.
All right, so thank you so much, Ms. Leal. Just make sure that you have that information for the state with regards to your restitution. And thank you so much for zooming in. And both the defense and state have agreed that for the restitution hearing, you are able to appear by Zoom. And that date is going to be March 4th. Okay?
Okay, thank you.
You're welcome. All right, thank you.
Judge, thank you.
Yes, he'll need to speak with probation. Thomas Lozano. Hello.
Hey.
All right. There's a violation report.
There is, Judge.
All right, this is something. Have you all come to an agreement on the violation report?
Judge, we did have a motion to amend the conditions of the bond.
Well, we need to start with the violation
Sure.
report. So have you all agreed on the violation report or no? No problem. Have you all had a chance to review the violation report?
Yes, sir. Review it. I don't, at this point, we haven't discussed changing the bond condition. It looks like it was just a matter of the defendant complying. He got into a van to go to the dog, that van had other stops. And so at this time, the state would just be asking that he not be allowed to do that, and I think that's the agreement with that as well.
Judge, he does work at Randolph Brooks. My understanding is that they do take a van to work because there's not adequate parking for all individuals. I was not a part of the initial hearing when GPS was placed. I think if I had been here, I would have expressed, I'm assuming, Ryan would have told me that that is part of his job, is that he does get in a van with other individuals. And they do make multiple stops on the way home. We are asking that he be at least allowed that opportunity if there is no parking on base. And then we also had a motion, Judge. He's the individual I had spoken with you and the state about that had farm animals. And he was asking for permission to be able to feed those animals during the week. The
And I
state-
think,
We are in agreement with that, Your Honor.
And Judge, I do have a motion.
Sure.
This was the original motion, Judge. So nothing's changed except for the last paragraph, which is just giving permission to travel to the Atascosa address.
Okay.
Okay. And Judge, there were two other things, and I hadn't spoken with Ashley about this, but he was asking for permission to go to church. I don't know if that's something that the court would allow.
no, and let me just tell you the reason why I'm not gonna allow it. Because you're before me first on a violation of pretrial conditions. You're making unauthorized stops. If everybody on GPS is allowed to make whatever stops they want, then they're not on GPS really. They're just doing what they want.
Understood, ma'am.
So there are not going to be any changes to the GPS until the court sees that you are following GPS conditions. So all of these stops that other people are making to the Mexican restaurant, to the Take 5 oil change, Tractor Supply, someplace on Jarrett Road, S Road, Tree Village, Ridge Arbor, Action Pond. So you're telling me Action Pond stopping there has something to do with your employment?
So, ma'am, so what we do is, that we write a band pool. So, we drop off people as, other people that work with us there on base. And we, drop them off, you know, at their stop, like, their wife will pick them up someplace and, you know, or at their residence or wherever it is that we pick them up. Yeah, it's a van share that, the government offers us, provides us with, because of the, lack of parking there where we work on base. Yes, ma'am.
Your Honor, I guess, I wasn't aware that it's an on-base thing.
Yes, ma'am, I work on base. I work for the Air Force, US Air Force.
All right, so you need to provide proof of that to them and provide other information that in fact it is a van share. If it's a van share, then I understand the unauthorized stops.
Right.
But if it is not a van share, the court doesn't understand that.
It's a via van share, ma'am. I can provide that.
All right, so you'll need to provide that.
Okay, thank you.
All right, so where are we on discovery?
Your Honor, I don't believe any of the cases that are at least before this court are indicted yet.
Yeah, they haven't been indicted, but I want us to be moving towards wherever we're gonna be, because I know this is an alleged interference with child custody. And those cases, usually there's all of these civil orders that have been filed and people want copies of civil orders. So everyone needs to start working on that.
Yes, Judge.
All right, is there anything else?
Yeah, Judge.
All right, thank you.
And just for clarification, the only thing you need is obviously proof that this is a van share to and
Mhm.
from work and
And
no other
proof that
conditions
he
change.
is actually at the base.
Okay.
All right.
I'll get this to you as quickly as possible.
Thank you. Zion Taylor. Hello. All right, where are we on discovery?
I believe, Judge, that our last discovery request came back with an answer, so I think that should be it.
Okay, and state, were you able to tender an offer?
Sure.
How old are you?
22.
All right, Ms. Ferguson, I need a 30-day reset for plea deadline date.
Thank you, Judge.
I can do this. Fifth of March. All right, you're coming back on March 5th. That would be your plea deadline date. Do you understand?
March 6th, Judge.
All right, I'm gonna get everybody a calendar. All right, March 6th is gonna be your reset date, okay?
Thank you. Maybe be excused after we sign.
Just a side note, did the facial piercings, did that hurt?
No, ma'am.
Okay, all right, I just wanted to know. Thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
Do you want a referral? Do you want a referral?
No, I do not. No. Joe Hernandez. Okay, thank you. Oh, and I need it back so I can put it in the system.
Judge, on this case, I believe that this is asking for a reset because he's got a plea to alleged crimes and misdemeanors that have pleaded those, and we're going to TIC this case.
All right, when will that be done?
Well, I have to get a setting from them in about 2 weeks, Judge, just to be sure.
All right, Ms. Ferguson, I need a 3-week reset on Hernandez for disposition.
Yes, ma'am. February 20th.
All right, February 20th. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you, Your Honor.
Thank you.
Just take a seat, sir. Attorney will bring you.
No problem. Thank you.
I'll step outside.
Thank you. James Ross. Who's the attorney for James Ross?
Okay. Yeah, they just called him to June 27th. You have to start trial back up.
All right. On James Ross, we're gonna recall that. Recall that in 2 weeks.
Okay.
What day?
That would be February 13th.
All right, Mr. Ross, you have your new attorney. We'll bring you back on February 13th. Eric Padilla. Court is calling 2024 CR 010675, State versus Eric Padilla. Can I have parties announced for the record for the state? Defense
Tony Jimenez.
and probation. This is an application. Counsel, have you received all discovery?
I have, Your Honor.
And did you review that with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Padilla, did you review the document? I'm sorry, Mr. Padilla, did you review the document entitled Application for Deferred Adjudication?
Yes, Your Honor.
With your attorney, did you understand it?
Yes, Your Honor.
Court finds that the state is in compliance with discovery. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
No, Your Honor, waiving count two, waiving the repeater enhancement, moving on count one alone.
Any objection?
None.
All right, did you understand in count one, you're charged with aggravated robbery? That's a first degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to $10,000 fine? Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Padilla, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count one. Punishment is to be assessed at 8 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. The state is silent on your application, and they will take in consideration 2024 CR 010691 and 2024 CR 010929. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is.
State, is that the plea?
One correction.
Yes.
It's not it's not a firm finding of deadly weapons, it's a firm finding that it is an offense that falls under that category that can be considered aggravated.
All
It's-
right.
It is a 65 years or older.
Ah, okay.
race. I did change the language in there.
All
so
right.
I know we read it that way, so that's the only.
All right. So did you understand that to be the plea?
Yes, Your Honor.
Did you understand that plea? And did you understand then the state is saying that the reason why they're proceeding on it as an aggravated robbery is due to the age of the complainant?
Yes, Your Honor.
All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? You give that to me. Sir, how do you plead?
No contest.
State any evidence? Any objection?
None.
States you may be excused. Did you review the waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Counsel, if you would like a PSI, I can give you a PSI, but it's going to be about 8 weeks. Otherwise, if you want, I can proceed in 2 weeks' time. You can have witnesses come in and I'll ask the state to give me any type of criminal history.
Yeah, I confer just to.
Sure.
After conferring with my client, Judge, if we could return in 2 weeks' time.
All right, Ms. Ferguson, I need 2 weeks and probation, there will not be a PSI or TAP.
February 13th.
All right, so we're going to come back on February 13th and I'll make my decision on your application based upon whatever evidence is presented.
Thank you.
All right, thank you.
Appreciate you.
Thank you.
A big excuse,
Yes, thank you. Good seeing you.
He said it was a collision involving injury. Oh, no.
So. And how's it in the system? It's collision. Okay, all right, thanks. All right. Sherry Cooper.
Yes, ma'am.
Yes. All right, are you proceeding on the motion?
Your Honor, I need to address the court.
Sure.
My boyfriend has just handed me her. She's an English citizen, a British citizen.
Okay.
The offer is for some time to do. I don't know what that's gonna do to her, so I think I need to get a reset to get a Padilla.
Yes. All right, Ms. Ferguson.
Yes, ma'am.
And do you have an attorney for that, counsel, or do you?
Like I said, I'm just new on the say, I've got some attorneys, but if you've got somebody that's.
Oh, no, I
quick.
mean, if you have someone, then we'll give you a reset for enough time for you to speak with them and for her to confer with them.
Yes, ma'am.
All right, Ms. Ferguson, recall this in 30 days.
Yes, ma'am. That would be March 6th.
All right, we're gonna come back on March 6th.
Yes, ma'am.
Okay.
And Ms. Ferguson's asked me if you would reinstate her on her GPS.
You all will have to file a motion.
I'm
I'm
sorry, Ms. Ferguson.
Thank you,
Would
Attorney
you like-
Ferguson. You have to file a motion.
Yes, ma'am.
All right, thank you.
Thank you.
Guzman. Velasquez. Did you make it to Hayes?
Yes, Your Honor,
Okay.
we did.
All right.
And for the record, that judge, I came here first, as you know.
Yes.
The judge over there, it's a white Anglo-Saxon judge, but I prefer this court rather than the other.
I do not understand that. But John,
Okay.
he says the judge is Anglo-Saxon. Do you have any other background information? I don't know. You know what, in the
Because
word,
there was a mention
in the
through the
word,
grapevine.
you know what, in the words of Chief Gillespie from In the Heat of the Night, you've given me something. I just don't know what to do with that. So there we go.
Never mind, I withdraw that.
Okay. So on Froland Velasquez,
Yes.
today is his plea deadline date. So does he want a jury trial? Either you all are going to enter into an agreement today, or either this is heading to jury trial.
He wants a jury trial, though.
Well, I mean, let's hear him. Do you wish to go to a jury trial?
Yes, yes, yes.
All right, so here's the thing. I always tell people, it's their decision whether or not they go to trial or not. Your attorney will advise you on their thoughts but ultimately it's your decision. Because at the end of the day, I have people who take probation and say they want to do a probation. Their attorney is not going to be doing the probation. So I'm going to ask you, you've had a chance to speak to your attorney. Do you want a jury trial?
Yes.
All right. So how long is this trial going to last?
There's two cases on separate instances of aggravated kidnapping.
Well, I mean, those are other defendants, right?
If I may.
Yes.
This defendant has two aggravated kidnappings, and you are will be proceeding on one, so on the one that we proceed on first, and put the other one on in punishment, so. But I guess it depends, you're gonna go to the judge or the jury.
But which one are you electing to go first?
Yeah, I only have one case for him.
When that was just indicted.
Las Cats.
I figured that.
Yeah.
Is that the 224?
What about case?
All right.
But I would say a week. There's a lot of moving parts and them putting the case together.
All right, Norma.
And also, Your Honor, I just received the discovery today, so,
How are you all just receiving discovery today?
well, I kept checking on the website and there was nothing there. So I
No,
brought
no.
it.
Is this a case that's been re-indicted?
No, it's a different instance, different situation, same charge. The case that they wanna go on is, allegedly happened August the 5th, 2022. The older case that had been before the court happened on or about August the 30th, 2022.
Judge, so my understanding, the cause number that ends in 5-8, it has been indicted and pending before the court for some time. The cause number that ends in 7-6 was just indicted in October of last year. And so we made the court aware of that at the last setting, and so that's why today this reset was that they could review the evidence and decide whether the defendant wanted to enter a plea or not. It was my understanding that Mr. Lau had already received the discovery, but then he told me that he didn't, so I re-downloaded it for him again, and provided it to him today. But that's just where we're at.
All right, the jury trial is going to be May 6th. The plea deadline date has expired, and that's May 6th for each case. So both parties need to be ready on both cases. You'll be brought over dressed for trial in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you'll need to do a clothing exchange. Counsel, if there's an issue with the clothing exchange, let the court know.
Yes, sir.
All right, thank you. Thank you so much. Marcy Martinez. Court is calling 2021 CR 4966 State versus Marcy Rose Martinez. Could I have parties announced for the record for the state?
I can Galloway for the state.
All right, Mr. Leal, if you'll move over so she can come through. No, the Ms. Martinez, okay.
Albert Chávez for Ms. Martinez.
And are you Ms. Martinez? Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Marcy Rose Martinez who was placed on deferred adjudication in 2021 CR 4966 for the offense of attempted fraudulent use or possession of identifying information on August 26, 2021 for a period of 2 years? Is that you?
Yes.
All right, state.
Violation of condition number 5 in Bear County, Texas, the defendant Marcy Rose Martinez, the then and there failed to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, October, November and December of 2022 in violation of condition number 5.
All right, so are you reading from the original motion to revoke?
Judge, it says here state supplement.
I don't have the state supplemental. Did you review the supplemental motion from the state to enter adjudication of guilt and revoke community supervision with your attorney?
We reviewed the one she has. State's motion to supplement any motion to enter adjudication of guilt.
All right, Ms. Martinez, did you review that with your attorney?
Yes, ma'am.
Then to the violation of condition number 5, how do you plea? True or not true? I'm sorry? Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? You need to say yes or no and speak up. Knowing that, do you still wish to plead true to violation? I'm sorry, this is a misdemeanor. Yeah. I don't know what's wrong with this paperwork. All right. So you're looking at up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yeah,
You need to speak so she can type it.
Yeah,
No, the answer is yes or no. Do you understand?
yes,
Knowing that, do you still wish to plead true to violation of condition number 5?
no.
All right, you want,
I think she's a little confused.
all right, so here's the thing. You've pled true to violation of condition number 5. Do you understand that? You need to say yes or no.
Yes.
All right, so you understand that you've pled true to violation of condition number 5?
Yes, ma'am.
Do you understand that in violation of condition number 5, they're saying that you didn't report?
Yes, ma'am.
And do you want to plead true to that? Yes or no?
Yes.
All right, do you understand because you've pled true to that, regardless of whatever agreement you have with the state, I can revoke you and sentence you up to a year in the Bexar County Jail
Yes, ma'am.
and up to a $4,000 fine? Did you understand?
Yes.
Knowing all those things, do you still wish to plead true to violation of condition number 5?
Yes.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There's not, Judge.
Judge, if I may, so there were some other violations, and I didn't say, but we're waiving them again, because just proceeding on with the one that we read. We don't have an agreement, and the state is asking not to enter an adjudication of guilt against the defendant, revoke for community supervision and sentence her to 1 year in the Boone County Jail.
All right, and what are you requesting?
Judge, I'm requesting reinstatement and I'd like to call my client as a witness.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
You can lower your hand, state your name for the record.
Rose Martinez.
Yes.
Thank you. So Ms. Martinez, you entered into a term of probation with the state back in 2001.
Yes, sir.
And when you did that, were you reporting to probation in person?
No, I didn't report.
How were you supposed to report?
Going to office.
Okay.
Going to the office.
And
All right,
so,
so here's the thing. You're whispering. The court reporter cannot hear you. I cannot hear you. So the testimony that your attorney is seeking to elicit from you, if you want me to make a decision on what you're saying, I need to hear you. Do you understand?
Yes, ma'am.
All right, you may continue.
thank you. And so, were you asked to report by Zoom?
I'm not sure. I couldn't hear because the phone kept on breaking up.
Were you doing your orientation on the phone
No, I was doing my court on the phone. on Zoom.
when you entered your plea?
Yes.
Okay, and so after you entered your plea, did you talk to someone from probation?
No, I wasn't able to do it.
Did anybody from probation call you?
No.
Did you call them?
No, because I didn't, well, I did, because I got to hear her, she said that my probation officer's name, so I tried getting a hold of her. Then, but I didn't get no answer, they didn't come back.
Okay, at the time, where were you living?
I was at the time.
Did you have a car?
No,
Did you have a job?
no.
Were you living on the street?
Mhm.
And so,
All right, so here's the thing. You need to stop with this stuff because guess what? The court reporter cannot take down and when they look at the record, doesn't mean anything to anybody. Do you understand? How old are you? How old are you?
I'm 38.
All right, so you're gonna have to open your mouth and speak so that the court reporter can hear you and so that I can hear you. You may continue.
thank you, Judge. And so you were homeless, you didn't have a car, didn't have a place to live, didn't have a job?
Yes.
And so, since then, here we are, 2025, when did you get arrested? Approximately,
Recently,
yes,
on the 12th.
okay, and, were you charged with a new offense? Had you been charged with any offense since 2021?
No.
And so were you homeless when you got arrested this time? Okay, and what's gonna be different this time if the judge would consider keeping you on probation?
You know, this time, hopefully, I'm trying to get into Haven for Hope, so that way I can stay on top of that as well.
I can't hear. I'm modeling.
You gotta speak up, please.
Feel like I can't open my phone, I can't open it.
So what would be different this time?
I'm trying to get help, you know, I'm trying to take my classes and stuff like that, everything that I need to take care of.
Okay, do you have any family support here in town?
No,
Do you have any adult children?
no,
Any siblings or parents?
no.
Okay. And so if the judge does give you probation, you're gonna try and go to Haven for Hope and see if they'll let you stay in the courtyard or something?
No, once I sign in, then I have to wait, she said like 2 weeks, maybe not even 2 weeks, maybe a week to get into the site, so that way I'll be signing.
Okay, all right. Thank you. No further questions, Judge.
Any other questions?
Yes. Ms. Martinez, so when you were placed on deferred adjudication back in 2021, you provided an address of 1919 Jamar to probation. So were you living at that address at that time?
I was, but my friend, she got kicked out.
Okay. And so did you notify probation that the address had changed?
No, because I have no idea.
Okay. And were you aware that probation had went to that address multiple times to try to get in contact with you?
No, because we would have that going on.
Okay. And as part of your conditions, you were allowed to report virtually, but you were also provided the option to report in person. So did you ever make any attempts to go down to the probation officer to let them know what was going on with you?
No, because I tried calling, but she said to get a hold of her first, but I didn't know that I couldn't have got a hold of them on the phone.
Okay. As part of your conditions as well, you were supposed to gain employment and provide proof of that within 30 days of being placed on probation. Did you comply with that condition?
No.
Okay. And then also you were ordered to take a parenting class. Did you ever do that?
No.
Okay. I have no further questions.
Any further questions?
No further questions, no further witnesses, just argument.
All right, I'll hear argument.
Judge, I would ask the court to consider putting her back on deferred. She's had a lot of financial reversals. She hasn't been able to get her act together. It's not from a desire to be out there committing crimes and doing wrong or, you know, creating victims. It's more, she needs assistance more than anything else. She's homeless. She didn't do what she needed to do, but she also didn't have a phone, didn't have a car, didn't have an apartment or a house or anything. So it's not as a disrespect to the system or the court, but more just a complete lack of resources on her part. So we would ask the court to consider keeping her on. If the court won't do that, we would ask the court to give her the shortest sentence possible on a class A. Could be as little as a day.
Okay. So I appreciate your defense counsel argument. I think it's a great argument, but this is what I don't understand. Why is it that people can't find resources when they're on probation, but they can find resources and rides to commit fraud because that's what you're here for, attempted fraud. So you are able to find a ride to steal from this person. And the complainant in this case, guess what? That complainant has to go out and who knows, maybe find a ride to change all of his bank accounts, to find a ride. And everybody knows how the Social Security office is. You have to go down there. And I think now you just go down there to set an appointment. They don't even see you. And then once you set an appointment, then you have to go back and you have to bring certain paperwork. And if you don't have that paperwork, they'll make you come back and then you get set off. So my question for you is, why can you find rides and resources to commit a crime, but you can't find rides or resources or pick up a phone and call probation to say, hey, I'm having issues? Explain that to the court.
I really wasn't thinking at the time, you know, that I went and did that. Yeah,
I'm sorry,
right.
what?
I wasn't thinking right at the time, you know, and yes, you know, when we're going to do something wrong, yeah, of course, we're gonna have a right to work, you know. Well, I tried to have it right there, but I didn't want to go down there for anything, you know, because I kept on calling and I tried getting a hold of them a couple of times. And
Wait a minute, you said you didn't want to go down there for a ride. Why?
I didn't want to go down there for anything because I already had called a few times. I left them my number for them to call me back and they never called me back. So I figured that they were busy and then we're going through that COVID. So I figured that they weren't even gonna allow me to get in there to see them at the time.
Okay. Is there anything else?
No, Judge.
All right, this is what the court is going to do. Court is finding you guilty. Court is going to sentence you to 1 year in the Bexar County Jail, give you credit for any time served. There's a $4,000 fine, time and money to run concurrent. There's to be no contact with Gennaro, Gennaro. Last name is, I think it's Locricio, Locriccio. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand?
Yes, ma'am.
All right, we can go off the record. Good luck to you. You're gonna have to do better. You understand?
Yes, ma'am.
Thank you.
Thank you, Your Honor.
You're welcome.
I also have another guy. I don't want to go out of order. It's Omar Herrera.
All right, you can have him brought up if you've given them the paper.
I've already conferred with the state. We have an agreement.
Okay, just give me 1 second. Oh, let's take this Corral on. Yes. 13. All right. Okay. Who's your next person?
Omar Herrera.
All right, Omar Herrera. Court is calling 2000. Ah, this is unindicted.
Yes.
Let me see. What's going on here? All right, court is calling why is it listed as a night mag? I'm telling you, this paperwork. All right, court is calling night mag number 761218, which I believe is 2024 PF 14822.
There's, Judge, there's actually two charges.
Okay.
And so there is the night mag, that's the original case. And then there's a new case, or not so new, but it's the most
All right,
recent
so
case.
on this one,
On the night mag case, I've talked to the bail bond company and they're okay with getting back on the bond. I talked to them, they explained that the reason they were gonna off bond is because he hadn't been in touch with them, but he's been in the Bexar County Jail since that whole time that he hasn't been in touch. So knowing that, they're okay with getting back on, staying on. On the new one, he's remanded without bond. So We're just asking for a bond. I've conferred with the state and they're in agreement to a $10,000 bond if the court is okay with that.
All right, court is calling 2024 PF 14822, State of Texas versus Omar Herrera. Can I have parties announced for the record for the state? Defense?
Albert Titus for Mr. Herrera.
And are you Mr. Herrera?
Yes, ma'am.
All right, on this cause, you're asking for a bond. Is that correct, counsel?
Yes, Your Honor.
All right, is there a proposed agreement?
Yes, Your Honor, it does.
All right, what is this criminal history?
For adult bodily injury hearing, violation of protected order, evading arrest, failure to ID, previous unauthorized use, and a less than a gram.
And the family violence matters, are any of those convictions?
Yeah.
All right, you want to raise your right hand for me?
Judge, I just realized something in talking with my client. He's gonna need an interpreter if he's gonna testify.
Okay, all right, thank you. Makai Williams.
Good afternoon, Your Honor.
Good afternoon.
My apologies for the dress. I was set with civil. Fortunately, that resolved, so I was able to make my appearance today.
All right, thank you. Just one moment. Court is calling 2024 CR 0943, State of Texas versus Makai Williams. Can I have parties announced for the record for the state? Defense?
Zachary Munoz.
And are you Mr. Williams?
Yes, ma'am.
All right, probation, there's an application. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, we received the discovery on the two cases before.
Court will find that the state is in compliance with discovery. Did you review the application for community supervision with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor, we did.
State, are you proceeding on the indictment as presented?
Proceeding on count one, waiving count two.
Any objection?
No objection, Your Honor.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault on a public servant? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
And also, we're proceeding in cause number 2024 CR 2022. And in that cause number as well, the court will find that the state is in compliance with discovery and state. I'm sorry, sir, on that count, did you review the indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
And state in that cause number, are you proceeding on the indictment as presented?
No, Your Honor, proceeding on count one, waiving counts 2 through 7.
No
Any
objection.
objection?
No objection.
And that cause number, the charge is the same as well. So the same admonitions I reviewed with you are the same that apply to that cause number as well. Do you understand?
Yes, ma'am.
And each cause number, you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering these plea bargain agreements, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in each of these cause numbers?
Yes, ma'am.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
In each of the cause numbers, do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, he does.
In each of the cause numbers, do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, we do.
Mr. Williams, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promise you anything other than the pleas?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. In each cause numbers, did you review the plea bargaining agreement with your attorney? Did you understand it?
Yes, ma'am.
In each cause number, the state is proceeding on count one. Punishment is to be assessed at 10 years in the prison. There's a $2,000 fine. The cases will run concurrently. They'll take in consideration in each cause number 2024 CR 2021 000416, 2025 PF 0099 and 2025 PF 00911 and 00912. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
Do you understand that to be the plea?
Yes, ma'am.
Did you review the waiver of appeal paragraph in each cause number with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No,
Outside the agreement, the state is requesting that your probation be for a term of 10 years. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then in each cause number, to count one, how do you plead? Guilty, not guilty, or no contest?
I plead guilty.
State any evidence.
Attachments, Your Honor.
no objection, Your Honor.
All right, in each cause numbers, did you review the waiver and steps with your attorney? Did you understand them and sign them in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Do you stipulate that you are the same person listed in the stipulation as Dwayne Williams?
Yes, ma'am.
All right. In each cause number, the court will find there's sufficient evidence to find you guilty. And in each cause number, the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, we ask to receive forward.
Anything you wish to say on behalf of your client?
Your Honor, we ask that you follow the recommendation of 10 years probation. My client unfortunately ended up in the system at a young age as a juvenile. That is the underlying sentence that he is currently on parole for. And then these cases resulted while he was in custody at the juvenile detention facilities. Mr. Williams, unfortunately suffers from some anger issues that I think could be addressed while on probation. He had a very troubled childhood, and that is no excuse to go around hitting juvenile corrections facility officers. But I think it paints a picture of Mr. Williams and the unfortunate incidents that have occurred that resulted in the charges before you today. I think placing on probation would be a good way for him to receive the structure that unfortunately he did not receive as a child.
and allow him to continue on with his life. He is 19 years old now and is hopeful to get this part of his life behind him and start anew.
All right. Do you have any family members in your life, any support system?
Yes, ma'am.
Who?
My mom, my dad.
All right. So then it doesn't appear you had a childhood that didn't have positive influences in it. Were they both positive influences?
Yeah, I met my dad when I was like 14, so it's really mainly my mom.
All right. So your mom, was she a positive influence in your life?
Yeah.
That's either yes or no.
Yes, ma'am.
All right. So why are you doing this nonsense?
I don't know. I just let my actions take place. I was really just mad.
All right, let me ask you this. Do you want to spend the rest of your life in somebody's prison?
No.
Then at some point in time, people will come before me and they say they had a horrible childhood. What I can tell you is some people have childhoods that's more horrible than others. Some people have what we assume were great childhoods. It turns out it wasn't. But at some point in your life, your horrible childhood can't be your reason for committing crimes. You understand?
Oh,
And what is with this 46 on your neck?
that was my football number.
All right, so you go from playing football to being in custody. Did you graduate from school?
Yes, ma'am.
And what are you planning on doing with the rest of your life?
Taking care of my kid
Oh, you have a child?
on the way.
All right. And what does your parents say about that?
Do better. Do better.
Yeah. So you graduated from high school. Do you have any other thing to fall back on other than a high school diploma?
I got MAC, mechanical air conditioning trade.
Okay. All right. In each cause number, the court is going to sentence you to 10 years in the prison, suspended and probated for 10 years, regular reporting by Zoom or in person, regular random UAs. Each cause number will run concurrent. There's going to be field visits 1 time per month until further notice. 200 hours of community service restitution. You're either going to complete a trade or go to college. And then the court will waive those 200 hours of community service restitution. If you don't want to complete a trade and better yourself so that you can financially support your child, then these 200 hours are going to be spent in the hot sun of Texas, picking trash up alongside the freeway. Do you understand? There's going to be proof of employment within 45 days, no employment as a home health care provider or with minors. I'm going to order parenting classes and anger management classes. TAP evaluation, follow results. Probation, is there anything else? It can be out of custody. Is there anything else you need from the court to be successful? Oh, I'm going to get to the other thing. Other than that, is there anything else you need to be successful?
I don't know.
All right, and state, do you have the dismissals that were taken in consideration?
Yes, sir.
Yes. And the court is signing the dismissals that have been previously stated into the record. Yes. Is there anything else?
Yes, Your Honor. We are more than fine with the conditions laid out by the court. Unfortunately, the timeline of the 45 days seeking employment, we'd ask that be stayed until he's actually released. Right now, he has a parole hold due to these cases that once they've are in the system entered as rejected, hopefully parole will lift that parole hold from him so he can get out. But until then, he's going to remain in custody while parole figures.
All right, Ms. Abrams. That time is to start running upon release. The probation term and also, not the probation term, but the time for the employment and his conditions, because he has parole issues. Yes. All right, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal in each of these cause numbers? With your attorney, did you understand it and sign it?
No.
Because this is plea bargaining agreement in each cause number, because I followed your plea bargaining agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you, okay? Do better.
Yes, ma'am.
All right, the court is calling 2022 CR 7417 State versus Kimberly Nieto. Hi, I didn't see you. I'll take you up next after this. Kimberly Nieto, who's the attorney? Oh, thank you.
Thank you.
Can I have parties announced for the record for the state
Opinion for the state of Texas.
defense?
Zachary Munoz.
And are you Miss Nieto?
Oh, yes, ma'am.
Are you proceeding with this motion?
Your Honor, my understanding is the state is going to be withdrawing the motion to revoke. All parties in agreement to the probation recommendation for her to continue on probation with a trip to ISF.
All right, so you all are withdrawing the motion?
We're withdrawing and asking the court to amend conditions to have the ISF issue.
All right. All right, the court will grant them, well, the court will sign the motion to withdraw once you present it. And alternate amend conditions to include ISF. And there's going to be partial GPS, waive fees upon release. And she's to remain in custody until transfer. Is there anything else?
Nothing further, Your Honor.
All right, thank you.
Thank you, Your Honor.
You're welcome. All right, if you all will come up. All right, we're back on the record in 2024 PF 14822. The parties restate their names for the record.
Albert Chides for Mr. Herrera.
All right, and we have an interpreter. If you could raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English? So help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record, please.
Carmen Tarragona Sáenz.
All right. And counsel, y'all have agreed to a bond amount of $10,000, is that correct?
Yes, Your Honor.
Mr. Herrera, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Sí, señora.
Yes, Your Honor.
All right, you can lower your hand. State your name for the record.
Omar Herrera.
Omar Herrera.
All right, do you have a place to live?
Sí, señora.
Yes, ma'am.
And do you have family members here?
Sí, señora.
Yes, ma'am.
And are you a US citizen?
Sí, señora.
Yes,
All
ma'am.
right, and I will tell you the reason why I asked that question is because if you are not, there are certain legal instructions I would need to give you or legal admonishments.
Okay.
Okay.
Okay, now I know that's not how you say that in Spanish.
Oh, okay. Está bien.
Okay. All right. So, have there been any mental health issues with you?
No, señora.
No, ma'am.
Right. Any drug use?
No, señora.
No, ma'am.
All right, then what the court is going to do is the court will follow your agreed recommendation for $10,000 for the bond.
Está bien.
All right, thank you very much.
Oh, but we're not done yet. So your bond is set at $10,000 and I'm going to do a GPS and I'm going to waive the fees. And it'll be GPS tracking.
Está bien.
And that will be until further notice.
That's fine.
All right. Is there anything else from either side?
No, Your Honor.
All right, thank you.
Gracias.
Oh, de nada.
You don't need me here.
All right.
Can you excuse your?
Yes, thank you so much.
Pleasure. All
right. Juan Robles. Court is calling 2024 CR 010898 State versus Juan Robles. Can I have parties announced for the record?
Megan Galloway for the state.
Christopher Ramos for the defendant.
And are you Mr. Robles?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I haven't, we did.
Court will find that the state is in compliance with discovery. Mr. Robles, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, I did, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
No, Your Honor, we moved to waive the habitual offender enhancement. And then we also moved to waive count 1 and count 3 and proceed on counts 2 and 4.
Any objection?
No objection.
All right, and count 2, you're charged with offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams, and in count 4, you're charged with evading arrest, detention of a vehicle. The range of punishment for count 2 is anywhere from 2 to 20 years in the prison and a possible fine of $10,000. And the range of punishment for count 4 is 2 to 10 years with a possible fine of $10,000. Did you understand those ranges of punishments?
Yes, I did.
And did you review the court admonishments with your attorney, and did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand in each of those counts, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state was calling the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police? Oh, I'm so sorry. Just 1 second. There's a slight issue. Just 1 second. Yeah, just 1 second. There's a slight issue, but if there's no objection, I'll just white it out. And it has to do with what y'all have on the plea portion. All right, so if there's no objection, I'll write the count numbers that are being waived on the plea paperwork. Is there going to be any objection to that?
No, Judge.
All right. So did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
No, ma'am. Oh, I mean, yes, yes. Okay, I'm sorry.
All right. Counsel, has your client been able to provide you with any defenses?
He had,
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Robles, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, I am.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I did.
According to the plea, you're proceeding on count 2 and 4. State is waiving counts 1 and 3, and the enhancement paragraph. Punishments be assessed at a cap of 6 years in the prison. There's a $2,000 fine, and the state opposes your application. Did you understand that to be the plea? Defense is at the plea?
Yes, ma'am.
State is at the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, ma'am.
Then to count 2, how do you plea?
No contest.
To count 4, how do you plea?
No contest.
State any evidence.
State offers state exhibit number 1 and attachments.
No objection.
All right, did you review the waivers and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call on the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication in each count. We can go off the record. Counsel, do you want a PSI or do you want just the court to proceed on any criminal history?
I think it would be more prudent to have a full PSI, Judge.
All right. Norma, I need a date for PSI, please, and TAP evaluation. Is there a need for a MIC evaluation?
Yes, Judge, based on my interaction.
All right. We need a PSI, TAP evaluation, and MIC evaluation.
March 20th.
All right. We'll come back on March 20th. At that time, the court will make a decision on your application.
Thank you, ma'am.
All right. Thank you.
Have a good day.
Thank you,
too.
Judge.
Dennis Johnson. All right, court is calling 2024 CR 3849. Just one moment. And probation has to stay longer.
Okay. Yeah.
You're fine? Okay, we'll proceed.
You sure?
Yes.
Okay.
All right, court is calling 2024 CR 3849 State versus Dennis Johnson. Can I have parties announced for the record for the state? Defense? And are you Dennis Johnson?
Yes, ma'am.
All right, you entered a plea on August 27th of no contest and a true to the enhancement paragraph. And we are now back for sentencing. And according to the plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison, and the state is silent on your application.
Oh, great.
All right. Did you review the TAP evaluation and the PSI report?
Yes, Judge.
Any objections?
No objection.
All right, defense, you may proceed.
Judge, the PSI seems to be very thorough. I know the court had an opportunity to look at. There was mention in the PSI that my client is actually taking college courses. And we just wanted to supplement that with the courses and the thing that he done. The first page has to do with the student loans and that type of things.
Okay.
But the rest has to do with the grades. He's taking courses in business, and he indicated even in PSI that he wanted to start his own company, a trucking company. So he thought it was probably prudent to go to school. He says he's halfway through with his associates. Where he gets his associates, and then he's going to decide whether he'll go further or use his associates to start his trucking business.
All right, so let's get to the crux of the situation. Why can't you do right? You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Dennis Johnson.
All right, why can't you do right?
Your Honor, I just made some mistakes.
No, you made some choices.
Some bad choices, yes, ma'am.
So why can't you make good choices?
Your Honor, I have been making good choices since I got out. I drove trucks for 4.5, 5 years. I enrolled in college while I was on the road. And then when I got back, I just continued with college from being on the road.
So my thing is like, why does it take people picking up a case to start doing right? And I will tell you, I was a defense attorney and I would always have these conversations with my clients. I always say, why must you be looking at prison time for you to do right? And I'm just trying to get into your mind to figure out why. Because obviously you're in college, so that means that you're intelligent.
Yes, ma'am.
Some people who go to college, maybe not, but it appears to me that you are very intelligent. I've seen some people who are going to college and they just breeze through. They don't have a major. We would say they were permanent college students. I couldn't afford to be a permanent college student. My mom wasn't allowed anyway. But why?
Ma'am, I made a bad choice. I don't want to sit here and give you any kind of excuse on why I evaded the police. It was just a bad choice I made, Your Honor. And I plan on doing better and finishing my college and starting up a trucking business. But I don't want to sit here and give you the run around or none of that, Your Honor. But I
appreciate that because, it's almost 5 o'clock. I'm here to sit and listen to the runaround if people want to give me the runaround, but I appreciate you not giving me the runaround.
Yes, ma'am.
So are you employed now?
No, ma'am, I'm not employed. I actually got off of the truck with the sum of about $55,000. And I was in CPS when I was younger, so my college is paid for it. So all of the tuition and fees, I get that back for myself. So I haven't worked since I got off the truck.
Okay. So who do you live with? How are you surviving?
I live alone. It's from funds I had from when I was in the trucking business for 4.5 to 5 years is around that amount of time. And then as well as my college funds.
All right. So here's what I'm going to tell you. The money that you have, if you keep, in the words of my grandmother, nibbling off of it, you're going to look up and your savings and whatever money you have is going to be zero.
Yes, ma'am.
So you're going to have to get employment. And I require people who are on probation, if I place them on probation, to obtain employment. Do you understand?
Yes, ma'am.
Okay. This is what the court is going to do. Court is going to sentence you to 8 years in the prison, suspended and probated for 8 years. There's a $1,500 fine, time, and money to run concurrent. There's to be proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. There's to be regular reporting by Zoom or in person, regular random UAs. There's to be 200 hours of community service restitution. You are either going to obtain your college degree or, follow up on your CDL license. If you do those two things, then the court will deem the community service hours satisfied. Take in consideration 2024 PF 10121. And I believe that's also JN 2416837. There's to be field visits 1 time per month for 4 months. Do you have any children?
No, ma'am.
Okay, that is so good. Thank you. You're not ready yet. Probation, is there anything else? Oh, the defensive driving course. Probation, is there anything else he needs? Oh, probated. Sorry.
grade school?
No. If he obtains his college education, or if you get your CDL license, the community service hours will be deemed satisfied. Thank you. Do you need anything else from the court?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. That pounding you felt in your chest, that was a pounding because you didn't know if you were going to be going to prison or not, right?
Yes, ma'am.
Everything you did to come in here to give me something to potentially place you on probation, you need to keep doing that. Because from here on out, everything you do, you're potentially looking at 8 years in the prison, so it can still happen. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Judge.
You're welcome. Who is here on Dennis Pena? And the only other people left for you guys, it's Jonathan Alfaro. Who's here on Jonathan Alfaro?
I am.
He's down here.
All right, just 1 second, counsel, you can stand here. On Jonathan Alfaro,
He was recently
sanity?
correct, but now there appears to me an issue. I spoke to the state. I'm gonna have to get him psyched again.
All right,
So my secretary, my legal assistant, Angel, has already started that process, and we'll have to file either this evening or tomorrow.
all right, Ms. Ferguson, on Jonathan Alfaro, can you give me a 60-day reset for a competency evaluation? All right, so Alfaro can go back. It is going to be set for their competency, just to get an update on the competency, and it is March 31st. Yes. And I'm sorry, counsel.
Sorry.
That's done. All right, court is calling 2025 CR 0003000, State versus Dennis Pena. Can I have parties announced for the record for the state? Defense?
Milton Butler representing Dennis Pena.
And are you Mr. Pena?
I am.
Counsel, have you received all discovery? Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Pena, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it?
Yes, I did.
And did you sign it?
Yes, I did.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do.
Oh, and we're also going on 2025 CR 0000299. Counsel, did you receive all of the discovery in that case as well?
I did.
In that case, the court will find that the state is in compliance with discovery. And Mr. Pena, in that cause number, did you review the application as well?
Yes, ma'am.
And each cause numbers, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it? And counsel, I'm sorry, in each cause number, do you waive the reading of the indictment? And state in each cause number, you're proceeding on the indictment as presented?
Yes, Judge.
Mr. Pena, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Did, John.
In each cause number, do you understand you're charged with harassment of a public servant as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I do understand.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call?
I do understand.
Did you understand by entering a plea in each of these cause numbers, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, ma'am.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Pena, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
I am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, punishment is to be assessed at 8 years in the prison. The cases will run concurrently. The state will take in consideration 2024 PF 11447 and 735944. Did you understand that to be the plea?
Actually, I believe probation was to be recommended, community supervision was to be recommended.
No, I'm saying what they're taking in consideration.
Oh.
And then the cases will run concurrent and then community supervision. Did you understand those to be the pleas in each cause number?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Your Honor.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
None.
Outside the agreement in each cause number, the state is recommending that your community supervision be for a term of 8 years. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
I did.
Then into each cause number, how do you plead? Guilty, not guilty, or no contest?
Contest.
State in each cause number, any evidence?
Objection.
In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. In each cause number, the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. We'd ask that you go along with the state's plea bargaining office.
All right. Are you employed?
Not at the moment.
All right. When's the last time you were employed and what did you do?
The dishwasher at Margaritaville, downtown the River Center Mall.
Okay. Do you have any children?
Right.
Do you have a place to live if you were released?
At my mom's.
Okay. And did you ask your mom if you could stay with her?
Yes, ma'am. I've been talking to her every day.
Okay. And is there any drug issues with you? All right. Well, why were you spitting on officers?
I was actually, me and the officer were just. He had thrown me to the ground and I was kind of upset at him and I made a bad decision and it was just a bad choice that I had done. Because he had thrown me to the ground, he had actually thrown me to the ground and threw me in the car and it was just a bad choice. It was just a.
All right, this is what the court is going to do in each cause number. The court is going to sentence you to 8 years in the prison, suspended and probated for 8 years, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days of release, no employment as a home health care provider or with minors, field visits 1 time per month for 3 months, 150 hours of community service restitution, and anger management. Probation, is there anything else? And I'm so sorry. Each case number will run concurrently. And the court is taking in consideration the previous cause numbers that were mentioned on the record as a part of the plea bargain agreement.
Yeah, approach, Your Honor.
Yes. All right, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you, okay?
Thank you so much, ma'am.
Oh, you're welcome.
I'm just over here and this is taking.
All right, the last case we're taking, it's Studemeyer. Counsel, you doing okay?
Yeah, I had to, I'm gonna stand up there for a minute. I gotta sit too long.
So we're here for restitution.
Yes, Your Honor.
All right, so what is happening with the restitution?
Was not able to contact the complainant to determine the amount of restitution they paid, so we have no evidence to present to the court.
All right, then there's no restitution. We're gonna go on the record. Court is calling 2022 CR 5897, State of Texas versus Tamika Studemeyer. Could I have parties announced for the record for the state?
Andrew Harrison,
Defense. Carl Basley, Your Honor.
And are you Ms. Studemeyer?
Stoudemire, yes, ma'am.
Stoudemire. One day I'm gonna get that right.
Yes, ma'am.
All right, we're here for a restitution hearing. This case was set for a restitution hearing on October 1st. It was reset for December 2nd. Then from December 2nd, it was recalled to December 16th. And then it was recalled for January 21st. And now we are here today. And state, where are we on the restitution amount?
as I said, off the record, we were not able to contact the complainants, so we are not able to present evidence as to a restitution amount, if any.
All right, defense?
Your Honor, just so the court further knows that in the discovery packet that was provided, there is reports from the body shops, and it says the body shop, the insurance paid everything. There's zero was paid by the customer. So that could be the reason why they weren't able to get a response. My understanding is probation officers didn't get a response to their letters either.
All right, then there will be no restitution ordered as a condition of probation. All right, and we can go off the record. Now we have some other issues. So I understand there was an issue with employment.
Yes, ma'am.
Yes.
And what is the issue?
Long story short, Your Honor, I went to go pick up my paycheck and I went to Ace Cash to cash my check. And I just showed Mr. Basil, my employer had insufficient funds and bounced our payroll.
There's a
Yes, ma'am.
text, there's a text you showed me from the cash place to that. And apparently there was, probation officer mentioned there was some kind of police report, but I don't know what's included in it. I don't know if it's related to that or not. I don't know. No one was able to pull it up.
Okay. So here's the thing about that. I understand that in many times in life, we have disappointments. And I can't even imagine working, putting in the full time, and then having the person not pay you and the check bounce. But there's a right way and a wrong way to address that. So all you can do is go to them and say, hey, you owe me the money, I should receive it. And if they don't pay you, then that's where you seek, legal remedies. So I'm going to tell you, don't hang around their place of business. Don't do any of that. You understand?
Yes, ma'am.
Okay.
Your Honor, I explained to her that if he doesn't pay it after the proper request, she could go to the DA's office.
Yes.
And look into possible charges.
Yes. All right. So here's the thing. This is just a bump in the road, and sometimes bumps in the road happens to us, and we have to respond to it correctly. We can't go back to responding to it the way we would normally do it. You understand?
Yes, ma'am.
Now, the last time I saw you, you were extremely happy because everything was working out for you. And now you've hit a bump in the road, and life will give us bumps in the road. But when we receive those bumps in the road, We just gotta push through it.
I'm sorry.
No, it's okay. So you received a bump in the road, and so now you just have to figure out how are you gonna respond to it. Now, your attorney has told you there are legal ways to respond to it, so you can respond to it in legal ways. But what you cannot do is you can't go back to that location because people will see that you're on probation and they will say things like, we told her to leave and she wouldn't leave, you know? All right, so your attorney will help you with that, okay?
Yes, ma'am.
All right, thank you, counsel.
Thank you.
Thank you.
Excuse, John.
Yes.
Line.
All right, we are done for today. It was yes. Oh, the restitution, there is no restitution. Yes. Deputy Moore. Now we know, we cannot have just a 100% afternoon docket. Unless we do it on Thursday, because I have to teach anyway, so I'll be here. Oh.
What you think about us, Judge?
I do.